he in effect applies for the postponement of his cross-examination by Mr. Tom Moyane's counsel, which was supposed to happen today. He says he applies for an order that he must appear on the 31st of August 2020, alternatively on a date to be agreed by all parties. Let me have the appearances.
Good morning, Chair. I am A.E. Franklin, SC, the evidence leader for this segment of the matter.
Yes, thank you, Mr. Franklin. Hang on one second. Do we have somebody who sanitizes today? If there is nobody who sanitizes, you can just speak from where you are. Yes.
Good morning, Chair. I'm Ms. Mbata and representing Minister Gordon in this application.
Yes.
I'm from the Office of the State Attorney.
Yes.
Thank you.
You're moving the application for a postponement?
Yes.
Well, this affidavit, which has been deposed to, not by the minister himself, by somebody who says she is the minister's chief of staff.
Indeed so.
All it says is that the minister is not available due to cabinet commitments. There does not appear to be any information about why those commitments are more important than appearing before this commission.
Chair, those were my instructions, that the minister is not available due to the commitments that he had at the cabinet. So,
mere cabinet appointments on their own can't be more important than appearing before this commission. There would need to be something more than just mere cabinet commitments. This commission has got a very limited time to finish its work. And cabinet commitments are work like everybody's work commitments. If everybody is going to say, I have work commitments, I can't appear before the commission on this day, then we are not going to finish this job.
with due respect, Chair, I think probably the application was not more into detail as to exactly what the minister is doing or what held him up at the cabinet. But I of the view that he does respect the commission and he has due respect for what is taking place here, and he does want to come and give evidence if.
And what I do know is that the president has told me that he has told the cabinet ministers that whenever anyone is required to cooperate with the commission, they must cooperate. It may be that our solution is just to make sure that summonses are issued against anyone who must appear before the commission, because there are just too many instances where people say they can't appear before the commission on a particular day. And I see here that the order sought is that his cross-examination should be
On the 31st.
postponed to the 31st of August 2020 or to a date to be agreed by all parties. I'm not going to postpone this matter to a date to be agreed by all parties, because if we are going to work like that, we won't get anywhere. Lawyers are busy, and if we are going to do that, we can't do our job. So I will postpone it. I'm not happy. I will postpone it to a date that I will fix that accords with the program of the Commission. And I saw that Mr. Tom Moyane's position was that although his counsel is not available from their side, they say they are not asking for a postponement, but they are, and they accept that the unavailability of counsel is not a good ground for a postponement. I'll postpone it. We'll fix a date, and if Mr. Moyane doesn't use that opportunity, he might forfeit his right to cross-examine, but we'll have to make sure that the minister is here on the date that is fixed, so that we want to finish the work of the Commission. And we are a few months away from the end of the term of the Commission, so we've got to use all the days that we have properly. So I think Mr. Moyane's counsel, okay, you may sit down.
Thank you, Chair.
Might wish to say something.
Thank you, Chair.
Yes, just put on your mic. Not mask, mic, microphone, yeah. No, the mask, yeah.
Thank you, Chairperson. My name is Mfesane Kasiboto. I'm an advocate at Dumanoko Group of Advocates. I record my appearance on behalf of Mr. Tom Moyane. Our position is as simple as you've recorded, Chairperson, that in principle we're not opposed to the application for the postponement. Be that as it may, we thought we'd honor the opportunity we've been granted by the Commission, that if you take the position that we proceed today, we're more than happy to. But with that being said, we understand the difficulty, which is that Mr. Odan is not in front of the Commission for cross-examination. And in principle, we accept that we're in your hands. We're happy with the 31st of August. Be that as it may, we want to place it on record as well that we're happy, we're at the hands of the Commission. I mean, obviously there'll be issues with the availability of lead counsel, because you'll understand, given the length of the matter, the involvement of counsel, there might be difficulties having to find counsel within a short period of time. But with that being said, we want to place it on record that we'll avail ourselves at the date that the Commission will decide, and if alternative means have to be made, we're happy to do so.
Okay, no, that's fine. Thank you.
Thank you, Chair.
Yes. Mr. Franklin, do you want to say anything?
Thank you, Chair. Nothing specific other than to echo the sentiments of the Chair that it is regrettable that the matter has to be postponed. The practical solution, as the Chair has already decided, is to set another date, and I understand that that will be done in communication between the Secretariat and the Chair.
Yes.
That is all I have to say.
Yes. No, thank you very much. I'll postpone it, and the date will be determined soon, and the date will give everyone enough time to make sure if they were not to be available, they make themselves available. cross-examination of Minister Godan, which was scheduled for today, is hereby postponed to a date that is yet to be determined. Those who wish to be excused are excused. Good morning, Mr. Soni.
Morning, Chairperson.
Yes, are you ready?
Yes, we are. Chairperson, we have asked Mr. Madimpe Mogashoa to give his evidence today. You will recall that earlier in July, we had intended calling Mr. Mr. Mogashoa, but he couldn't come on account of the fact that he was not feeling too well on that.
I think bring your mic a little closer. Your
Yes, as you please.
voice is going down.
Yes.
Yes.
Sorry.
Yes. Well, he gives evidence in relation to PRASA, and
That is
he'll
so.
be giving evidence in relation to his role as the attorney for PRASA in regard to among others, I guess, I don't know whether it's among others, but the SIAC claims or cases and his interaction with the PRASA legal team as well as with the chairperson at the time, Judge Makubela now.
That
Yes,
is,
that's what he will be giving evidence about.
that is so, Chairperson.
Yes.
Chairperson, may I place on record at the outset that last night the Commission received an objection from Judge Makubela, who said that she'd been the notice that she'd been given that Mr. Mogashoa would be testifying today was too short. Place on record that she was given notice on Saturday. Also placed on record, Chairperson, that the decision to call Mr. Mogashoa was made on Friday, and that's when all the parties, including Mr. Mogashoa, was decided.
Well, I must just indicate that the calling of Mr. Mogashoa today or sometime this week emanated from me in order to try and make sure that we use the time available as much as possible. It did not emanate from Mr. Soni or anyone else. And to the extent that Judge Makubela might have been given short notice, one, she will have access to the transcript of Mr. Mogashoa's evidence, and actually the acting secretary should send her a letter indicating to her how to access the transcript of Mr. Mogashoa's evidence. And in this regard, also, it's to be noted that she has not made any application for leave to cross-examine Mr. Mogashoa. Indeed, other than the fact that when she gave evidence, she denied having asked or instructed Mr. Mogashoa not to speak to the PRASA legal team about the CIA claims. Other than that, as far as I know, she has not filed any affidavit disputing anything in Mr. Mogashoa's affidavit. Is that your understanding as well?
That is the position as I know it.
Yes.
Chairperson, yes.
So other than that one denial, she hasn't sought to tell us that she disputes Mr. Mogashoa's affidavit, or at least she has not done that by way of filing an affidavit, despite the fact that she has had Mr. Mogashoa's affidavit for a long time. Yeah. So I don't think that she should be prejudiced in any way other than that she could have come to sit here while Mr. Mogashoa was giving evidence. She would not be allowed to cross-examine him because she hasn't applied for leave to cross-examine. All she would do is just listen, and she will be able to read all the evidence in a transcript. Yeah. So I just thought I must clarify that the decision didn't come from you. It came from me.
As you
Yeah.
please, Chairperson.
Okay, all right.
May we have leave to call on? Mr.
Yes,
Mogashoa?
please administer the oath or affirmation.
Please keep your mic on. Please state your full names for the record.
Madimpe Mogashoa.
Do you have any objection to taking the prescribed affirmation?
No?
Do you solemnly affirm that the evidence will give will be the truth, the whole truth and nothing else but the truth? If so, please raise your right hand and say, I truly affirm.
I truly affirm.
Thank you.
Thank you very much. You may be seated.
Mr. Mogashoa, it's common cause that you are an attorney and that you have acted for PRASA in certain matters. I'm just placing that on record.
Yes.
In relation to the evidence you are about to give today, have you made an affidavit?
Yes, I have, Chair.
Have you that affidavit in front of you?
Yes, it is in front of me.
Chairperson, the affidavit is in bundle G. It is marked Exhibit SS13, and it starts at page 1, Chairperson.
So the bundle is bundle G,
Yes.
and
Exhibit SS13, it's the first
yes,
document in that bundle, Chairperson.
yes, and you would like Mr. Mogashoa's affidavit to be admitted as exhibit
SS13.
double S13.
As you please, Chairperson.
That affidavit, Mr. Mogashoa, does it appear on page 1 and goes up to page 19? If you look at the red numbers on the top right-hand corner of the pages.
That is correct, Chair.
Yes, and that signature is your signature above the certification.
It is my signature, Chair.
Yes, thank you. Mr. Mogashoa's affidavit is admitted as exhibit SS13.
As you please. Ms. Mogashoa, could you very briefly tell the chairperson how it came about that you made this affidavit? Just very briefly.
Okay, Chair, I received a call
I'm sorry, Mr. Mogashoa, please bring the mic a little closer to you.
this way.
Yes, I don't know if it moves. If it moves, I want it to be a little closer even than that, or maybe you move your chair. I hear better when it's not too far away from you.
Okay, Chair. I received a call, it must have been around April of this year, from Ms. Rangata, who indicated that in these proceedings, officials of PRASA came through to the commission to give their evidence, in particular in relation to some of the matters that my firm, the Mogashoa attorneys, the matters that the Mogashoa attorneys was involved in, and that they were in particular matters in relation to the CIA, what I see is referred to as the CIA group of companies. She then asked that it is only courtesy that she requests that I assist by making my own affidavit available. I was subsequent to that given a copy of Ms. Ngoye's affidavit, and I think at that time she was either still testifying or had just finished testifying, but what I was given was a copy of her affidavit. I'm made to believe that it forms part of the documents I might be talking to this morning. I then received a letter from the commission explaining precisely what was needed from me and the firm I am part of. Because the last time I was involved in the matters was way back in 2017 and 2018, I kept on indicating to Ms. Rangata that I needed more time because I had to plow through documents, most of which we have already archived. But in answer to the question, Chair, that's how I got to eventually formulate and settle this affidavit that is before us now.
In regard to the contents of your affidavit, was the commission legal team or anybody from the commission involved in the formulation of your affidavit?
I formulated and settled the affidavit myself, Chair.
Now, in your affidavit, you referred to the affidavits by two PRASA officials, Ms. Ngoyi, whom you've mentioned, and was there a second person whose affidavit you received?
I received the affidavit of Ms. Ngoye initially when I was approached to be of assistance to the commission. And I think subsequent to that, but before I could settle the affidavit as requested, I was given the affidavit of Mr. Dingizwayo. I believe at that time, Mr. Dingizwayo had not come through to the commission to give his evidence, Chair. I may have been placed in possession of Ms. Ngoye's transcript, but I have not seen Mr. Dingizwayo, but I believe he has given his evidence. So I was in possession of the two affidavits at the time of formulating this affidavit.
Now, in the affidavit, did you read the affidavits that were given to you?
I went through both affidavits that were
In
given.
their affidavits, they mentioned their interactions with you and your firm and your interactions with PRASA in relation to the CIA matters. Just in general, what is your response to the averments made in their respective applications insofar as it concerns you and your firm?
Okay. Let me start by explaining that I understand and I understood at the time I was asked to prepare an affidavit the role that I had to fulfill by offering explanations, which Mr. Ngoye and Mr. Nikizwayo may not have had enough information around. As my affidavit says, and in the normal, ordinary course of accepting instructions from PRASA Chair, which we acted for, I received, I think during the period of 2015, it must have been around September, I could be wrong, but the dates are in my affidavit. I received about 4 summonses, all by different companies, which I see we refer to as the CIA group, and all of which were in respect of claims by the CIA group against PRASA, purportedly as a result of services rendered through a variety of contracts or agreements that PRASA and CIA may have gotten themselves involved in. And I believe that in the beginning of 2016, the year that followed, I was then instructed on 2 more, to defend 2 more of such summonses by entities that are perhaps part of what we call the CIA group now. Now, my instructions, Chair, were that our firm should defend PRASA in as far as the summonses were concerned. I recall very well that during 2015, just after we had entered appearance to defend in respect of the 2015 case numbers, which I speak of in my affidavit, our opponents, and I think my opponent colleague was Mr. Matopo of Matopo Attorneys, he represented the CIA group of companies. They immediately proceeded to file an application for summary judgment in respect of all of the matters. Now, naturally, through consultations with client, it came out that client had a basis to want to defend those 4 matters at that time, and that is what the legal team, which our firm was a part of, carried on to then file opposing papers in the defense of PRASA and in illustrating to the court at the time that PRASA had bona fide defenses to defend the matters. I suppose it's on record now that the summary judgment applications were successfully opposed, and then the parties then went on to litigate. As for instance, I may have been instructed by our client to litigate in the manner that we did through the various stages of such litigation. And I think in 2016, when we received the 2 additional summonses, we went on to file our appearances to defend as instructed, and my opponent, I think, in this case, did not go on to file applications for summary judgment in respect of such matters, and we then went on to exchange pleadings, and one can accept that in that respect, there would have had to be many occasions during which my firm would consult with PRASA and PRASA officials, and I think in particular it will be Ms. Ngoye, Mr. Dingizoyo, and Ms. Mukotedi. I had received all of these instructions from Ms. Mukotedi through, I believe, Mr. Dingizoyo's instructions. In the process of dealing with the litigated matters, it became apparent that the contracts that opponents relied upon made reference to arbitration as one way of having the matters adjudicated upon. And I think the parties at some point during 2016 or 2017 agreed to then have the matters referred for arbitration. My affidavit speaks about all processes thereabout, and I think Ms. Ngoye's affidavit speaks about such processes thereabout. And the parties agreed after obviously some bit of tiffing and towing about who the suitable arbitrator would be. We eventually agreed on instructing retired Judge Fritz Brand. I recall that we subsequently had a pre-trial, pre-arbitration meeting with Judge Fritz, at which we then agreed on the many various steps that the parties would follow in preparing the matters for the arbitration hearing. And if my memory serves me well, we had intended to sit around certain dates of September of 2017 so that we argue the cases as pleaded in the numerous documents that we had at our disposal.
Mr. Son, it will be important to let him talk to each claim to say what was it about. And I mean, the question of their defense is in the public domain because pleas were filed, as I understand it, was what the defense was or defenses were, how much was claimed, what was that claim for, what was the defense of PRASA, just briefly.
Yes. I'll do that in a moment because he does, there is a report from Mr. Mogashoa which I want to deal with in that regard, Chairperson.
But it's important as whoever is listening, as they follow, they know what claims we are talking about.
Yes.
It's easy for all three of us because we know, we have read this, but somebody who is listening doesn't know what are these claims for, and if we go too far without explaining them, they are disadvantaged.
I just wanted to cover a formal issue.
Yes, no, that's fine.
The question I had asked you, and where you gave the history of the matter, was, did you read Ms. Ngoyi's and Mr. Dingizwayo's affidavit? They make a number of allegations. I'm just asking, are you in agreement with those allegations they make in their affidavits, or do you disagree with it, just in general?
The Chair, there would be certain aspects of their affidavit or their affidavits that I disagree with, and I do state that very clearly in my own affidavit where
you
I think they did not quite capture the facts of the matter in line with what I know the facts to be. So every aspect of their affidavits that deviated from what I know about these matters, I would have had to deal with.
So I think your answer, Mr. Mogashoa, should be your attitude to the allegations made in Ms. Ngoye's affidavit is as reflected in the affidavit, because there you deal with that. Those that you admit, you make that clear. Where you think it's not, it doesn't give the full picture as you understand it, you have also dealt with that. Is that right?
That's correct, Chair.
Yeah, and then Mr. Soni can take you to those if it's necessary.
Can I just ask you to look at paragraph 7 of your affidavit, Mr. Mogashoa?
What paragraph?
Paragraph 7 on page 3, Chairperson.
Okay.
You say in the first sentence, I had an opportunity to consider the affidavits of Ms. Ngoi and Mr. Dingizwayo, as well as the documents in the group. And then just read the second sentence, please.
I confirm that the amendments contained in these affidavits are a correct recollection of the events that took place, except where I otherwise in this affidavit prefer better clarity and or put issues into their proper perspective in areas where our firm's involvement was concerned.
Yes. And then if you look at paragraph 8, you make one point about an allegation made by Mr. Dingizwayo that the settlement that had been concluded in December 2017 was a secret settlement, and you say there was no secret settlement. Is that the extent of your dispute between yourself and Ms. Ngoi and Ms. Dingizwayo, except where something else appears in your affidavit?
Well, yes, except where something else appears in my affidavit, I had to categorically state that the assertion that in as far as our firm was concerned, the assertion that the settlement processes were done secretly, I did not quite think that that would be correct in the context of our firm's involvement in the matters.
To the extent that when Mr. Dingizwayo referred to a secret settlement or anything along those lines, to the extent that he may have meant that it was a settlement in which the legal department of PRASA, of which he was part, had not taken part or had been excluded. Would you be able to comment on that?
I would accept that proposition, Chair, if he means it in a sense that perhaps the legal department was not aware.
Yes.
About what was happening.
Yes.
About the settlements at that time.
Yes.
I don't have a problem with that proposition.
Okay.
I'm going to come back to that, Chairperson. I don't want to be asking leading questions, but that is an important issue.
Yes, that's fine.
Now, in regard to the 6 matters that you've mentioned, Mr. Mogashoa, did you at any stage do a report for PRASA?
You mean in the ordinary, I just want clarity on your question. You mean in the ordinary course of dealing with the matters, or the dealing with the litigation, as the case may be?
Can I ask you to please look at Annexure MN4 to Ms. Ngoi's affidavit, please? Ms. Ngoi's affidavit, Chairperson, is in bundle E1, Exhibit SS7B.
And which page would that be?
If you look at page 322, that's MN4.
I have it in front of me, yes.
Now, what is that document?
This is a report compiled by our office.
Well, who from your office?
I prepared the report with my colleague, Nabeka Zimbebe.
What was that report about?
We were, prior to this date, requested by the legal department to prepare a status report in respect of all of the matters our firm was defending for PRASA at that time. I think in my discussions with Mr. Ngoye or Mr. Tingizwayo, I was made to believe that the board wanted to have a quick update on the status of the litigation of the matters related to the CIA group. And in that way, we then, Ms. Mbebe and I then went on to prepare this report. I have it dated the 21st of November, 2017.
Yes. Now, let's just put this in perspective. This is a report you prepared for PRASA, would that be correct?
That is correct. Right.
And what you say is that the purpose is to provide the client with an update on the background of the CIS summons our office has been instructed to defend. That's at paragraph 1.2.
That is correct.
Now, in the rest of the document, you then outline each of the cases. Would that be correct?
That is correct.
Okay. So let's look at the first one, which is, Chairperson, this is answering your question about what the claim is about and so on. Look at the one at paragraph 2.1 on page 322. What case number is that?
The report then refers to a matter with case number 73934 of 2015.
And who was the claimant in the matter, or the plaintiff?
The plaintiff then is CIRDB Consulting Engineers Pty Ltd.
Yes.
And obviously it was a summons against PRASA.
And at paragraph 2.1.2, you indicate the basis on which that claim is, the claim is founded. Could you just indicate what that was for, what the basis was, as set out in paragraph 2.1.2?
Correct. We say in our report, Chair, that the plaintiff alleges in his particulars of claim dated 9th of September 2015 that on or about 8 September 2014 at Braamfontein, Johannesburg, the plaintiff, represented by its managing director, Makenza Mabunda, and the defendant, represented by its group CEO, Lucky Tsepo Montana, concluded a written consultancy agreement for the PRASA Rail Infrastructure Rehabilitation Program Phase 2.
And in at paragraph 5.1, at paragraph 2.1.3, you indicate what the contract price was.
Correct.
And what was the contract price?
Our paragraph 5.1 of the report says the contract price was 28,819,200 rand, inclusive of VAT. And I think we cross-referenced to clause number 1.11 of, I imagine, whatever agreement or document that was attached to the summons.
Okay. Now, can I ask you to look at page 324, and in paragraph 2.1.9, you set out the first defense that had been raised. What was that defense? Just very briefly, you don't have to read it.
And that is paragraph 2.1.9. I see here that I'm making reference to an issue that has to do with jurisdiction.
Yes.
I don't know if that's what you're referring to.
Yes. I'm just trying to articulate what the issues were in this matter. There is a claim, and you indicated that you had said to PRASA that these claims are defendable, and we're just looking at the bases on which the claims were being defended.
Yes, and you deal with those at 2.1.9, 2.1.10, 2.1.11.
Correct, that is
Yeah,
indeed so.
just articulate them. The defenses.
Oh, okay.
Yeah.
I may need to look at them at the same
you
time,
can-
but without reading, Chair.
You can read these ones, yeah, because
Yes, must I
there were
read them
three
into the
defenses.
record, in the record?
Into the record, yeah.
All right, that's fine. We're saying in paragraph 2.1.9 that the amended plea raised the issue of jurisdiction in that clause 20 of the agreement, upon which the plaintiff relies upon provides that disputes between parties must be referred to arbitration, and that the present dispute had not been referred to arbitration.
If you could just stop there for a moment.
Yes.
When you were summarizing the developments in this matter, you indicated to the chairperson that matters had been filed in court. And then you indicated that eventually the matters were referred to Judge Brandt as the arbitrator.
That is correct.
Was the appointment of Judge Brandt connected with this defense?
It will be connected with this defense, but I imagine at that time, the parties had not gotten into any arrangement that the matters be referred for arbitration.
This must be a point that you had raised when the matter was still in court, and you must have raised it successfully, even if it was not decided by the
Adjudicated.
court, successfully in the sense that the plaintiff agreed that they should not have gone to court, they should have referred the dispute to arbitration.
Yes, indeed so, Chair. It would be, and we say there that it was included in our amended plea that there were jurisdictional issues in the sense that the matters ought to have been referred for arbitration in the stead of the institution of an action or action proceedings out of the High Court.
Well, was that point common to all the CIA claims that ultimately got settled, or only in regard to this matter, as you recall?
We agreed to have all of the disputed matters go for arbitration. So in that agreement, it may indeed be so that not all of them had to be referred for arbitration.
Yes.
But I think when we were discussing all of them with
may have been
legal
convenient.
counsel and my opponent on the other side,
Yeah.
we then arrived at a conclusion that because they are similar and they rely on agreements purportedly entered into between PRASA and the group of CIA companies, that it would serve justice better that we then refer all of them for arbitration. So yes, Chair, in answer to your question, there was an agreement to also refer the so-called settled matters for arbitration at that time.
Okay, maybe you can
In
finish.
answer, I will go through all of them, but in
Yeah.
answer to the question, Chairperson, without leading the witness, that is indeed the position that the jurisdictional point was taken in respect of all the contracts.
Okay, you are away from the mic, as a
I'm
result I
sorry.
can't hear.
Yes, sorry.
Yes, I didn't hear, just repeat the point.
The jurisdictional point was taken in regard to all 6 claims.
All 6 claims, oh, okay, thank you.
All right, then, Mr. Mogashoa, if you look at paragraph 2.1.10, you indicate what the second defense was in the plea that had been filed in the High Court. What was that defense?
Correct. We say in paragraph 2.1.10 that the second defense raised in the plea is that the services indicated to have been rendered on the invoices upon which the plaintiff relies are not of any of the services listed in the annexure POC or POC 3. In other words, the payments claimed for by plaintiff under this summons are not authorized by the consultancy agreement upon which the plaintiff relies, and on that basis, defendant is not liable to the plaintiff on such amounts.
So, just to clarify that, would it be correct to say that PRASA's defense in relation to this claim as reflected in paragraph 2.1.10 was that CIA may have performed those services, but those were not services that PRASA had asked CIA to perform?
Indeed so, Chair.
Yes, and that Ziaya could not claim from PRASA payment for services that had not been agreed should be performed by Ziaya.
These things happened a long time ago, Chair, but I would imagine that we had difficulties with the fact that what we came across as evidence of amounts that the CIA group was saying were outstanding. The invoices and what the invoices articulated by way of the services rendered were not in consonance with the agreement, and in particular Annexure POC 3. So this may have been confirmed by our client during the various consultations we may have had with them, that they had challenges with those invoices as they did not seem to relate to any of the services as may have been prescribed by this annexure to the agreement.
Okay.
And then at paragraph 2.1.11, you articulate what the third defense was. Could you indicate to the chairperson what that was, even if you just read paragraph 2.1.11 into the record?
Okay, we say, Chair, in paragraph 2.1.11, that the third defense raised in the plea is that the plaintiff is not entitled, I imagine, to interest because they did not demand payment of such various amounts on the date alleged in its particulars of claim, and therefore they are not entitled to interest with effect from those dates. I imagine it will be the dates of the invoices themselves.
Now, in paragraph 2.1.12, you refer to a further defense that was raised. Could you indicate what that defense was?
Chair, we say in paragraph 2.1.12 that the defense also relied on clause 11.1 of this consultancy agreement to allege that the invoices upon which the plaintiff relies are not in accordance with the payment schedule contemplated in clause 11.1 of the consultancy agreements, due to the fact that the amounts claimed therein are not the amounts provided for the payment schedule contained in Annexure B to the consultancy agreement. In the premises, insofar as amounts claimed by plaintiff are not in accordance with the amounts provided for in the payment schedule contained in Annexure B to the consultancy agreement, the defendant pleads that the plaintiff is in law not entitled to claim such amounts in terms of the consultancy agreement, and the defendant is therefore not liable to the plaintiff in terms of the consultancy agreement upon which the plaintiff relies.
And then in paragraph 2.1.13, you raise a further defense in respect of reciprocal obligations. Can you articulate what that defense was, even if you just read it out?
Chair, in paragraph 2.1.13, we say that the defense also relied on the fact that clause 1.12.4 of the consultancy agreement created reciprocal obligations between the parties. The clause provides that the plaintiff commits an event of default if it does not deliver a certificate of occupation within a period of 20 days from the project completion date. The plaintiff has not delivered the certificate of occupation referred to in clause 1.12.4 of the consultancy agreement, and it is for this reason not in law entitled to enforce the consultancy agreement against the defendant.
And then in 2.1.14, you raise an even further defense. What is that?
We say in 2.1.14, Chair, that the plea also contested the lawfulness of the variation of the consultancy agreement to the extent that it is not contemplated in clause 23 of the agreement.
And 2.1.15 indicates what your last plea to this claim was, and what was that?
We say there, Chair, that lastly, the plea dealt with the defendant's denial of the fact that the services the plaintiff alleges to have rendered are in consonant with services listed in POC of its particulars of claim.
Now, earlier on, you indicated that the claims were not consonant with POC 3. Was this a separate defense as well? Because here you refer to POC 2.
I just want to read 2.1.5 again. We seem, my understanding of this paragraph is that we seem to also deny that the services rendered are in line with the services as may have been listed in Annexure POC2 of the particulars of claim.
Yes. I'm just going, if you look at paragraph 2.1.10 on the previous page, you'll see there's a reference to POC 3. I'm just saying that it appears as if there were 3 sets of particulars of claim, and that 2.1.10 referred to one, and this referred to yet another.
I suppose you mean annexures and not...
Sorry, annexures, yes.
Yes. So yes, from the reading of my report, indeed, there would have been POC annexures, and we seem to be saying both their reliance on POC 3 and POC 2 were found to be wanting in our interpretation of the documents in their totality at that time.
Mr. Mogashoa, let me just try and understand. These defenses were based upon what? In other words, how did it come about that these defenses exist?
We would have had to consult.
Well, you would have not.
We went on to arrange on many instances and occasions consultations with clients. Documents were made available to us. Information was shared with us by members of the particular unit, which unit would purportedly have received such services as may appear in the allegations in the particulars of claim. So the defenses were formulated as a result of consultations and as a result of documents that were availed to us as legal team. And naturally, that which followed was that we repeated all of these defenses in the plea as may have been amended that we filed on behalf of PRASA.
Now, in regard to the drafting of the plea, this is a claim for 27 million rand. Did you have counsel?
Yes, we had counsel. I think I do say in my affidavit that initially in 2015, we were instructed to brief Advocate Mike Maretz, SC, and with him, Kennedy Tsatsawani, as his junior. And I think it was up to the point we argued applications for summary judgment. But I think from then onwards, we were instructed to proceed with Advocate Tsatsawani. I can't remember if at the time his silk status had been deferred, but we proceeded with him, and over time, we're instructed to get a junior for him.
I'm just trying, sorry.
At the time of filing these pleas, yes, Advocate Tsatsawani and Mawande Sethi.
I'm just trying to find out whether council drafted the pleas.
It would have been council who drafted the pleas, correct?
All right, then let's look at the next case, which you set out at paragraph 2.2 of annexure MN4. And what case number is that?
We are saying here that it is case number 73933 of 2015.
And who was the claimant in this matter?
The plaintiff in this matter is Yaya DB Consulting Engineers Pty Ltd against PRASA.
And in paragraph 2.2.2, you indicate what the basis of this claim was. Could you read that into the record?
We summarize the plaintiff's case to be that on or about the 4th of December 2013 and at Braamfontein, Johannesburg, the plaintiff represented by its managing director, Mackenzie Mabunda, and the defendant represented by its chief executive officer entered into a written accelerated infrastructure refurbishment project consulting agreement.
I'm just asking if you recall, who was the chief operating officer, the defendant's chief operating
Chief Executive Officer.
Chief executive officer, sorry.
In 2013, it may have still been Mr. Lucky Montana. It may have still
Well,
been
in
Lucky
2013,
Montana.
it certainly would have been Mr. Montana,
Yes. Yes.
because he left in 2015, if I recall correctly. Or was it 2014? But in 2013, I'm sure it was still him.
Yes.
Yeah.
And if you look, Mr. Mogashoa, if you turn to to paragraph 2.1.2, it's on the previous page 323, and you look at paragraph 2.1.2, you do name the CEO there.
Yes, that is indeed so.
And who is the CEO then?
It says Lucky Tsepo Montana.
Yes. And that agreement was 2014, and the chairperson is making the point that therefore in 2013, it must have been Mr. Montana as well.
Indeed, so I'm just not sure whether we left the information out regarding who the chief executive officer at the time was, or that this is just a caption of what the particulars of claim say.
If you look at the first line of the next page, that's page 326, and that's your paragraph 2.2.3, you indicate what the purchase price, the contract price of this contract was. What was it?
We say there that the contract price was 24,978,000 rand, inclusive of VAT.
And then from paragraph 2.2.8 on page 327, you indicate the basis on which the plea was founded. And what is 2.2.8?
Chair, we say in paragraph 2.2.8 that the amended plea raised the issue of jurisdiction in that clause 19 of the agreement upon which plaintiff relies provides that disputes between parties must be referred to arbitration and that the present dispute had not been referred to arbitration.
This is the point that the chairperson was asking about. Did all the was the same jurisdictional point taken in respect of all the contracts? Certainly it was taken in respect of this contract as well.
Indeed so, Chair, if the report confirms that, because I think the report was done when our firm was still seized with the responsibility of defending the matters.
But at the time you drew up this report, you would have had everything in front of you.
We had everything in front of us, correct.
Now, 2.2.9, you indicate a further defense. What was that defense?
We say there that the defendant also denied that the agreement was entered into by its chief executive officer, and as well the correctness of clause 3.2 of the agreement.
And in 2.2.10,
I'm sorry.
oh, sorry.
On 2.2.9, is that defense one that disputed the validity of any of the agreement that was entered into by PRASA's chief executive officer at the time? Or was the defense that factually no agreement existed? Do you remember? Is that something you are not able to remember?
I can't quite remember, Chair, but just to assist, if I give regard to paragraph 2.2.9, we either did not have an agreement at all, or alternatively, we had an agreement that did not bear any signature of the chief executive officer and or any other official from PRASA who may have been mandated to enter into such an agreement. So we disputed the existence of the agreement from my reading of 2.2.9.
Okay.
And then in 2.2.10, you raise a further defense, and what was that?
We say there that the plea also alleges that the defendant is not liable to the plaintiff due to the fact that the plaintiff failed to provide it with an occupation certificate as contemplated in clause 1.11 of the agreement.
Okay. And 2.2.11, what's the defense raised there?
We say there that the defendant disputed its liability to the plaintiff in that the invoices upon which the plaintiff rely are not consistent with the provisions of clause 2 of Annexure B to the agreement, in that they do not set out the work for which amounts are claimed. They are not for any of the amounts listed in clause 2.1 of Annexure B to the agreement. They are not for 25% of the contract price as provided for in clause 2.2 of Annexure B to the agreement, and they are not accompanied by the deliverables prescribed for each of the invoices provided for in clause 2.2 of Annexure B of the agreement.
And then in 2.2.12, a further defense is raised. What is that?
We say there that the defendant also denied that the plaintiff rendered the services provided for in clause 8 of the agreement read with Schedule A of the agreement.
This seems to be similar to the plea in the, or the defense raised in the previous one, namely that the annexure, POC 2 and POC 3, don't bear out the claims that were made by the plaintiff.
That is indeed correct.
And then in 2.2.13,
we say there that the defendant also challenges the plaintiff's claim that it is entitled to interest as at 25 March 2015, as no case had been made in its particulars of claim for the interest to be paid with effect from that date.
and that's similar to the defense you raised in the previous claim. With that
In the previous case number, correct.
Then, in paragraph 2.3, you deal with the next claim that was made, and would you, in paragraph 2.3.2, you indicate what the basis of that claim was?
We say there that it is case number 74281 of 2015, and it is by CIRDB Consulting Engineers Pty Ltd against PRASA. In paragraph 2.3.2 of the report, we say that the plaintiff, in its particulars of claim dated 09 September 2015, alleges that during or about 4 March 2013 at Braamfontein, Johannesburg, the plaintiff, represented by its managing director, Mr. Makenza Mabunda, and the defendant, represented by Dr. Daniel Mtimkulu, head of PRASA Engineering Services, concluded an oral agreement. We say in brackets, the material management and coding agreement.
Now, you say that that was an oral agreement. Well, that is what it was alleged.
That is what is pleaded in the particulars of claim.
Yes. What was the amount that is claimed? I think you'll find it at paragraph 2.3.6. On page 329.
The plaintiff alleges that the defendant is indebted to it to the sum of 17,628,118 rand 59 cents.
Now, in regard to the amount of the claim, the particulars of claim alleged that there was a 17 million rand contract concluded by an organ of state on the basis of an oral agreement.
That's what the particulars of claim say.
Then, if you look at your defenses, they start at 2.3.10. Could you indicate what those defenses are?
Chair, we say on paragraph 2.3.10 that the plea denied the conclusion of the alleged oral agreements between plaintiff and its representatives. In the alternative, it is alleged that Mtimkulu was not duly authorized by the defendant to conclude the agreement on behalf of the defendant. The defendant did not at any time represent the plaintiff, or represent to the plaintiff rather, that Mtimkulu was authorized to conclude the agreement on its behalf. The defendant is in law not bound by the agreement, and the agreement is in law not enforceable against it. And the plaintiff ought to have attached to its particulars of claim the written part of the agreement, and its failure to do so is prejudicial to the formulation of the defendant's defense.
Before we go on with the rest of the defenses, may I make or raise this with you? The chairperson had earlier asked you whether the question of the jurisdictional point was taken in respect of all the claims. Why could it not be taken in respect of this claim?
I imagine it is because there was no agreement to refer to wherein such a clause existed, that in the event of a dispute, the matter be referred for arbitration.
Which made it different from the other written agreements.
I imagine, yeah, indeed so. This would be different from the others.
All right, then in 2.3.11, you raise a further defense is raised, and what is that?
We say there that, in addition, the defendant pleaded that the project charter attached to POC 1 of the amended particulars of claim was not prepared by it, that no agreement was reached between the parties regarding its contents, that plaintiff had no capacity and skills to render the services indicated therein, and that plaintiff did not render any of the services for which payment is claimed.
Right, and in 2.3.12, Chairperson, sorry, may I indicate, I understand it is tea time. I'm just wondering if I shouldn't finish this and then we could break for tea. It's
Oh, okay, all right.
clauses.
Okay.
2.3.12,
In 2.3.12, we say that the defendant also admitted receipt of the plaintiff's invoices, but pleaded that the plaintiff did not render services for which the invoices were rendered, and that plaintiff did not deliver the deliverables contemplated in such invoices. It is pleaded further that some of the invoices submitted by the plaintiff do not fall under any of what the plaintiff alleges was the scope of works as contemplated in POC 1 and POC 2.
now this again harks back to what was said in respect of two other claims. In other words, there's a disjuncture between the claim and the annexures that the plaintiff had relied on.
That is indeed so.
Those are the defenses in regard to this claim. Mr. Chairperson, maybe this would be the ideal.
Yes, I understood you to say you wanted to just wrap up on that one before we...
Those were the two.
Before we
There
take
are no more.
adjournment. I thought let's take the tea adjournment, and when we come back, you finalize the remaining claims if you haven't covered all the ones you wanted to cover.
I thought we would cover all the claims, Chairperson, and it has an importance in relation to the fact that an agreement was reached.
No, that's fine. We will. All I'm saying is let's take the tea break now.
Yes.
And
yes.
when we
So,
come back,
yes.
you can
No,
continue.
yes.
Yeah.
I'm sorry.
We'll adjourn for tea now, and it's 22 minutes past 11. We will resume at 22:12. We adjourn.
All rise.
I can.
Yeah. These are the
cooperation in the following projects.
Yes, and then now that's an MOU, and then at 2.4.3, you indicate more specifically what the claim was based on.
We say there that the plaintiff alleges further that pursuant to the conclusion of the MOU, the parties entered into a written agreement on the 30th of July 2013 with the plaintiff duly represented by Ms. Solani Vuma and the defendant by Mr. Lucky Montana.
All right. Then you set out the defenses, which start at paragraph 2.4.8 on page 331.
Yes, we then state in our paragraph 2.4.8, Chair, that the defendant's plea indicated that in the light of the fact that the validity period of the consultancy agreement between the plaintiff and the defendant commenced on 15 July 2013, it follows that such validity period came to an end by no later than 28 February 2014. In the premise, there was no longer an agreement between the plaintiff and the defendant in terms of which the plaintiff could lawfully render services to the defendant and in terms of which the defendant would be obliged to make payment I'm sure we wanted to say to the plaintiff, due to the fact that the consultancy agreement upon which the plaintiff relies had come to an end by a fraction of time by no later than 28 February 2014. Accordingly, the defendant is not, in terms of the consultancy agreement upon which the plaintiff relies, liable to the plaintiff for any services allegedly rendered by the plaintiff after 28 February 2014 or for the damages claimed in these proceedings.
Right. Then you raise three other defenses at paragraphs 2.4.9, 2.4.10, and 2.4.11. What are those?
We, in those paragraphs, say that the first one, the plea also denies that the plaintiff ever carried out additional scope of work, which was not contemplated in the consultancy agreement upon which plaintiff relies. Alternatively, that the work that plaintiff alleges to have carried out was authorized by the defendant. The defendant also denies that the plaintiff ever presented a concept design to the depot steering committee. Secondly, we say that the plea also raised a defense that by the time the motivations referred to in the plaintiff's particulars of claim were submitted, the term from the consultancy agreement had lapsed and that it was no longer competent for the plaintiff to submit the motivation/variation orders. And lastly, we say that the plea also alleges that the plaintiff acted in an unreasonable and negligent manner in believing that the services were rendered as contemplated in the consultancy agreement, and that the variation orders were not authorized by the defendant, and that plaintiff failed to realize that the consultancy agreement contract had lapsed.
Then the fifth claim is reflected at paragraph 2.5. Who was the claimant in that matter?
The claimant in the matter of the plaintiff is Rail Solutions, Pty Ltd, against PRASA, and I see that the report says that it's under case number 47597 of 2016.
Yes. And if you look at paragraph 2.5.5, you'll see what the amount of that claim is, or the amount of the contract.
The paragraph states that further that the parties agreed that the plaintiff will render services to the defendant in terms of the aforementioned agreement whose contract price was an amount of 69 million rand, inclusive of that.
And if you look at paragraph 2.5.8, that reflects, that's on page 333, the amount of the claim. And what was that amount?
Sorry, Chair, which paragraph?
Paragraph 2.5.8 at the top of page 333.
Okay, our paragraph says that it is as a result of this breach of agreement that plaintiff now claims that the defendant is indebted to it to an amount of 21,626,138 rand.
I'm sure you meant alleged breach there.
Well, yes, Chair, I'm sure it's repeated in other paragraphs that it's an allegation.
I'm sure CIA would have been happy to see that you didn't say alleged, you said breach.
Yes.
Yes, Mr. Soni.
As you please, Chairperson. And then at paragraph 2.5.10, you set out the first leg of the defense or the first defense.
We say there that the defendant's plea disputed the fact that plaintiff's current claim is based on a consultancy agreement and same is therefore irrelevant for purposes of this proceedings.
All right. And at 2.5.11, you raise a further defense.
We state there that the plea further denied the conclusion of the additional service agreement, and in the alternative, we pleaded that in the event that it is found that the additional services agreement was concluded between the plaintiff and defendant, then in that event, the defendant pleads as follows: that the conclusion of the additional services agreement was not duly authorized by the defendant, that Sonic Baltak was not duly authorized to conclude the additional services agreement, that the defendant did not at any stage represent to the plaintiff that Sonic Baltak was duly authorized to conclude the additional services agreement referred to in paragraph 11 of the particulars of claim, and lastly, that the additional services agreement upon which the plaintiff relies is not valid and binding upon defendant, and it is in law unenforceable against defendant due to the fact that its conclusion was not duly authorized by the defendant.
And then at 2.5.12, you raise a further defense is set out. What is that?
We say there that the defendant also alleged that the contents of Annexure S3 of the plaintiff's particulars of claim does not indicate or suggest the alleged conclusion of a written agreement, and that same cannot be construed to constitute a written agreement.
And paragraph 2.5.13.
We say there that the defendant's plea admits that HAC did not submit a variation order, but defendant denies that same is linked to the alleged additional service agreement.
And in 2.5.14 and 15, you raise two further defenses are raised. What are those?
We're saying defendant also denied that the plaintiff ever submitted a report setting out services rendered, and that the invoices submitted by the plaintiff were ever adequately explained to the plaintiff, or by the plaintiff rather. And we then also say that the defendant denies that it made any representations relating to approvals, authorizations, and variations in relation to services allegedly rendered by the plaintiff.
Okay. Then the sixth claim is reflected at paragraph 2.6. But before I ask you to set out what that claim is, can I ask you please to look at paragraph 2.6.8 on page 334 in relation to that claim?
Yes, I see the paragraph.
What does that say?
The paragraph says that on the 13th of April 2016, we received correspondence from our opponents who informed us that their client had been paid the full amount that they were claiming and proposed that the defendant tenders the cost of the proceedings. We thereafter sought instructions from client to no avail.
But effectively, what was the effect of the fact that payment had been made?
The matter, in as far as the litigation is concerned, was not proceeded with.
In other words, it had become settled effectively.
it had become settled. I believe that at some point, client confirmed that position, and we went on to close our file.
Now, Ms. Mogashoa, what was the purpose of your drawing up this report?
Maybe before that,
As-
it would appear that in all of these claims, CIR claims that you have covered, in all except one, the plaintiff was the same, namely CIR, DB, Engineering Consulting Pty Limited. And the only one where the plaintiff seems to have been a different legal entity, though also under CIR, was the one called CIR Rail Solutions Pty Limited. Is my observation correct?
Correct, it is indeed so.
Okay.
As it is. So, Ms. Mogashoa, come back to my question. What was the purpose of this memorandum report, whatever one wants to call it?
We were instructed by the legal department of PRASA to prepare the report, and in my understanding, the board or the chairperson of the board had called for it. But I remember we were told that there was a need for us to urgently prepare a status report in respect of all of the CIR matters that our firm was defending.
Now, based on this report and based on the defenses that had been raised, and having regard to the instructions you had received, what was your view, you were the instructing attorney, of the prospects of successfully defending these claims?
Before he answers, if he is able to answer, that's fine. I'm just thinking that if you are involved in the matter, you might have discussions with your client, and for whatever happens, you might not want to tell other people what you told your client about the merits.
Yes.
But if he feels comfortable, that would be fine.
Yes.
You understand that?
Yes,
yes. And it may well be that an opinion on the prospects may be based on the legal department of PRASA, what they took, or on somebody independent other than the person who was handling it. But if he feels comfortable to answer the question, there is no problem.
Chairperson, with respect, you've made a separate a point that is separately valid, and that is, we know as a fact that the claims have not been pursued since the Judge Tuckman's order.
Yes.
And it may be inappropriate.
Yes.
So I withdraw the question.
Yeah. Okay, well, that's fine.
Now, this is a report that's dated the 21st of November 2017. Is that correct, Mr. Mogashoa?
Correct, that is the date of the report.
All right. Now, let's go back to your affidavit, which is SS 13. In bundle G. After you submitted this report, what happened?
Can I interrupt you
Yes,
again,
yes, there's a question.
Mr. Soni? Please don't forget your question. I made a note in regard to this report, Mr. Mogashoa, to the effect that it did not deal with the merits of the claims, by which I meant it said nothing about prospects of success. And I think at the beginning of the report, there is a note you made towards along the lines that it should not be read as constituting your advice on the way forward or that kind of thing. You remember that note?
Would it be, Chair, on the first page of the report we just went through now?
Yes, yes, yes.
You look at paragraph 1.3, I think that's where you make the disclaimer, Mr. Mogashoa.
So I got the impression when I read that part that you did not want it. Your intention was not to say anything about the prospects of success, but it was just to say what has happened and where are we with regard to this litigation. Is that correct?
That is indeed so, Chair. I think my paragraph 1.3, if you look at it, it invites client to call for such a report if they need it.
If they need it, yeah. Yes, yes, yes. I think the reason why I made that note may have been that I read somewhere, and I don't know if it was Judge Makubela's document, but I read somewhere, I think, where somebody said, but the report doesn't deal with the prospects of success or the merits. And I went to look at the report and I picked that up, that it didn't deal with that. But I think I only saw the note at the beginning of your report when Mr. Soni was pointing it out earlier. So you did not intend in that report to express any view on the prospects of success, but you expected client to approach you if they wanted such an opinion.
Correct. I think the update report, as I understood the instruction at the time, was that I provide status report on the nature of the claims and what our attitude as PRASA is towards them. And I think this is precisely what I did. We all know, as members of the same profession, how challenging such requests from clients are when you are expected to almost give some idea what the court would do with the cases in as far as the merits are concerned. So ours would be to be comfortable about the information and evidence that is available to us and advise our clients that we are of the view that the defenses would carry. And we were at that point prepared to follow through with that instructions to defend PRASA in all of these matters, given the information available to us at the time.
Okay.
Now, as I say, this report is dated the 21st of November.
Correct.
Thereafter, there is a report here dated the 28th of October from you.
Correct.
Well, before we get to that report, what led to that report being prepared by yourself?
After we dispatched with the report that we've just gone through of the 21st of November, I think a couple of days down the line, I received a call and an email from Mr. Dinkizwayo which had attached what we now know was a memorandum from the chairperson of the board, in which there were certain inquiries that the chair had put to, I imagine, PRASA's legal team or legal department, and in respect of which Mr. Dingizo's request was that I comment on the areas of the memorandum that made reference to our firm or to our involvement in the matters. And I think this is precisely how I then considered the memorandum that was availed to me and prepared the second report,
Yes.
if I may call it that.
But before we get to your second report, let's look at the document that you referred to that Mr. Dingiswayo gave you. Have a look at MN6.
Of which bundle?
Sorry, that's an annexure to Ms. Ngoyi's affidavit, bundle E1, page 344.
Yes, I'm on it.
Is this the memorandum you're talking about?
I'm sorry, at what page is it?
Page 344, Chairperson.
On the same bundle?
Of Ms.
one.
Ngoyi's, of E1, yes, Chairperson.
If I'm not mistaken, I may have attached what I received at that time. I'm not sure if they are the same. If you allow me-
No,
I'm sorry.
sorry, I must apologize. Please look at MN5, not MN7.
What page is MN5?
338.
Page 338, okay.
Is this the memorandum you received?
I think this is the memorandum I received. If you don't mind me checking, I may have referred to a memo as well. I just want to see.
Yes, it's at paragraph 23 of your affidavit, Mr. Mogashoa.
But did I attach it? Isn't it
No, you
attached?
didn't.
Okay, that's fine.
You referred to MN5 in paragraph 23.
That's fine. Then this is the memo.
Yes. Now, we don't have to go through the whole memo. There's just certain parts that I want to go through. Who is the memo addressed to?
It says here that it's addressed to the acting Group Chief Executive Officer, Mr. Zide.
Yes. And from whom is it?
It says it's from the Chairperson, Interim Board, Advocate T.A.N. Makubele SC.
And what is the date of the memo?
It says 28 November 2017.
And what is the subject matter?
CII Consulting Engineering Pty Ltd, in brackets in liquidation, inquiry in terms of section 417(1) and 418(2) of the Companies Act 61 of 1974.
Now, this is a memorandum, this is a report. This is the section 417 report that you refer to quite often in your affidavit. Would I be correct?
Well, yes, it may be so.
I'm not saying you, I'm saying the reference is made to it.
I've made reference to it.
Now, until today, had you seen that report, the liquidation report?
You mean the report that is a subject matter?
Yes.
Yeah. No, I was never placed in possession of a copy of that report. I knew it existed, but
Face
a
this
copy
side,
was-
and don't be too far
Sorry,
from
Chair.
because I can't hear you when you are too far from the mic, and certainly when you're looking
I'm beginning
away.
to like Mr. Soni better, I see.
I see you are not the only witness who does that. I think a lot of witnesses like the evidence leaders more than the chairperson.
I
Yes.
think they're more intimidated by the evidence readers.
Thank you, Chair. To answer the question, I have not seen the report up until today.
Okay. Now, before we get to the report, and I just wanted to place it in context because that's the subject matter. This is addressed to Mr. Zide, the memorandum from the chairperson.
Correct,
In your preparation for the CIA pleas and the developments thereafter, what communications did you have with Mr. Zide?
I think at that point in time, none whatsoever. I had been engaging with the legal department, and I think in the beginning I said Ms. Ngoye, Mr. Dingizwayo, and Ms. Mukotedi.
Those are the people with whom you dealt in regard to the CIA matters.
In regard to the CIA matters, correct?
And as at the date of this memo, had you had any dealings with the chairperson of the interim board, Judge now Judge Makubele?
When you say dealings, are you referring to whether
Interactions, personal interactions.
personal interactions? Yes, when she was an advocate of the Pretoria Bar Council. I believe. I've had to work with her when I was at the previous law firm. I used to be a partner at Geldenes Malachi.
But in regard to PRASA?
In regards to PRASA at this stage, no, not at all.
All right. Now, this memo was sent to you by Mr. Dingizwayo.
Correct.
Let's just have a look at what the memo says. If you look at paragraph 1, you could just read that into the record.
The memo says that I refer to various...
Sorry, could you see, identify to whom it is addressed?
It is addressed to Mr. Zide.
But the memo then starts off with,
Dear Mr. Zide.
yes.
And paragraph 1 thereof says, I refer to various discussions between us about this matter as well as our brief discussion with the group executive, legal risk and compliance, Ms. Mathangoye, on 14 November 2017.
Yes. Then the next paragraph refers to your report, which we've just been through. That's MN4, would that be correct?
Yes, it refers to our report dated 21 November 2017.
Yes. Then she makes the point that CIA DB had been placed under liquidation. That's the last paragraph, the last sentence of that paragraph. Would that be correct?
Yes, I'm aware that in our course of dealing with the group, some of their companies went into liquidation.
Right.
And at that time, which is November 2017, yes, we were fully aware as PRASA's legal representatives that there were liquidations proceedings that were or had been conducted.
Yeah. If you turn to paragraph 3, you see what the chairperson says about your firm's role in it. Just read that into the record, please.
It says it is not clear from the report of Mogashoa Diale attorneys whether they were subsequently appointed to represent PRASA to deal with the liquidation matter. As acting group CEO, such instructions would have come from you.
Well, if we could just pause there for a moment. Did you receive instructions from PRASA in regard to the liquidation matter?
Yes, correct, we did.
Right. And from whom in PRASA?
It would have been from legal, either the three PRASA colleagues I've made reference to. So because they would instruct me interchangeably. But when I communicate, I would communicate to one and carbon copy the others. So I can't quite remember who in particular gave me the instructions, but the instruction came from either Ms. Ngoye, Mr. Tingizoya, or Ms. Mukotedi.
Would you copy Mr. Z there on those matters?
No, I did not have to.
And why do you say that? You didn't have to?
Because he had not been involved at any stage with any of the matters or in any of what we as legal representatives would have had to deal with on behalf of PRASA in defending the matters.
How long had you been acting for PRASA as at the time of this memo, which is November 2017?
You mean our firm or?
Yes, no, your firm.
Our firm has been doing work for PRASA since 2012.
And during that period, whom were your communications with, yours and your firm's
It
communications?
would have been with the legal department on what we call corporate matters, or it would have been with the insurance department if it is liability instruction.
But in regard to the litigation with whom,
Corporate litigation, it would have been Mr. Ngoye, Mr. Tingizoya, or Ms. Mukotedi.
and what role would the CEO play in that process?
We have not had to deal with the CEO in respect of the matters we were dealing with at the time.
Then in paragraph 4, the chairperson makes a point about the arbitration, and she asks whether it happened before or after the liquidation application. Can you, well, just have a look at paragraph 4.
Must I read it out?
Yes, okay.
It also appears from the report that at some point the matters were referred to arbitration, but what is not clear is whether this happened before CIA Consulting Engineers went into liquidation or not.
And can you shed any light on that?
But I think if we had agreed, and I could be wrong, but my recollection tells me that at the time we agreed as parties to refer the matters for liquidation.
For arbitration.
For arbitration, rather, information had not come forth at the time that there were liquidation proceedings in respect of this group of companies. But it came out that way before we could have arbitration proceedings to hear the matter that a group of companies, or some of them, had volunteered to be liquidated.
So the fact that there had been liquidation didn't affect the referral to arbitration. Would that be correct?
Not necessarily. I think on our side and for our part, we then encouraged the legal representative of the group of matters to give us the relevant Rule 7.1 authority to continue acting for them, even though there may have been a provisional liquidation order at the time, I can't remember, and which mandates we received from Matopo attorneys.
All right. Then paragraph 5, perhaps you should read that into the record.
Paragraph 5 states that you are aware that attorneys acting for CIA Consulting Engineers approached on or about 14 November 2017, and that they provided me with a copy of an interim report of the inquiry in terms of the Companies Act that was prepared by the Commissioner and dated 15 September 2017. They also attached copies of email communication between Mr. Madimpe Mogashoa of Mogashoa Diale and Advocate Francois Botes SC. The email communication is also attached in Mogashoa Diale attorney's report.
Now, this interim report is the interim report in relation to the 417 inquiry. Would that be correct?
I imagine so. I can't say it with certainty, but the subject refers to that inquiry in terms of section 417.
But Mr. Mogashoa, let's get to, on a number of occasions in your affidavit, you say, I've not seen the report. What report are you talking about?
It must be this report.
It is this report.
Well, I accept that. I saw the report only today. So there will be challenges on my part to confirm with precision what all of these reports talk about when they talk about the interim report. I saw it only today.
Yes, okay. Now, in regard to this report, referral is made to it here, and then you thereafter met the chairperson of the board later, and at that, we're going to come to it, referral was made to this report as well. What was your attitude towards commenting on the effect of the report on the litigation or the prospects of the defenses succeeding?
Whenever the report would be mentioned, I would make the point that it would be difficult for me to comment on it in relation to the litigation without having seen it. And I made the point that although we had agreed at the conclusion of the liquidation inquiry hearings that the report be made available to us, redacted as may be, the report was never made available to us. I believe I made inquiries from my opponents whether they had received the report themselves or not. I don't think I received any answer that was positive in that regard. We may have also written to the Commissioner to inquire about the availability of the report, and we never got a copy of such a report until I started hearing about it around November, December, when we then were involved in meetings with PRASA represented by the chairperson.
Now, in paragraph 6, the chairperson refers to certain communications from PRASA members. Could you just read that into the report and we can deal with that in a moment?
The report further reads on paragraph 6 that in their report, the Mogashoa attorneys indicated that they became aware on 20 August 2017 after receiving communication from PRASA that certain members have received subpoena to appear in the liquidation inquiry. They attended the inquiry but were not allowed to cross-examine witnesses. They also allege that the Commissioner has not provided them with a report.
Okay, and that paragraph continues on the next page.
Oh, does it? Then it continues to say, you have noted from the bundle of the documents from CIS attorneys that these assertions may not be entirely correct.
Now, just pause for a moment. This is she's talking about the assertions that your firm made. That's what the chairperson is talking about.
That's what I understand her to be saying, correct?
Well, are any of those assertions incorrect?
No, they are correct. Specifically, if it is about whether we had at that time received the report or the interim report or not.
And then she continues on, if you could continue with paragraph 6.
All right, it says, however, as acting group CEO, the instructions with regard to the liquidation inquiry, proceedings and handling of the High Court actions would have come from you. Kindly confirm the nature of the instructions that were given to Mogashoa Diale in this regard. Please attach copies of such instructions.
And what is your reaction to that? That the instructions would have come from Mr. Zide?
I think in the second report that I prepared, we deal with what is contained in the chairperson's report, and we clarify issues that may have at the time been of concern to us as a law firm. So obviously the instructions that our firm had been receiving up to that point were from legal. There would not have been any interaction between us and the acting CEO when it comes to the, say, a group of litigated matters.
All right. Then read paragraph 7, please.
It reads that it is clear from the interim report of the Commissioner that the witnesses that testified at the liquidation inquiry include former and existing employees of PRASA. These witnesses would have attended the inquiry with your knowledge and understanding of the evidence that they were going to tender.
And then paragraph 8.
It reads that should the contents of the Commissioner's report be correct, it is clear that the witnesses made major concessions with regard to the liability of PRASA in the civil actions launched by CIA Consulting Engineers, now in liquidation. However, despite these concessions, Mogashoa Diale appeared to still want to proceed with the arbitration proceedings. They, however, did not address the prospects of success at that arbitration proceedings in view of the evidence that has already been led at the liquidation inquiry.
And then it continues. I want to ask you a few questions on paragraph 8. Just finish paragraph 8, please.
All right, it continues to say, kindly confirm if these are your instructions to Mogashoa Diale and the nature of evidence and witnesses that you intend to lead at the pending arbitration proceedings.
Now, let's just deal with the assertion that the witnesses made major concessions at the arbitration. Now, these are the PRASA witnesses. Let's get your role at the arbitration. You were allowed to sit for part of the Section 417 inquiry. Would that be correct?
Correct.
And that would be in regard to the PRASA employees.
PRASA employees, yeah, who were at the time still in PRASA's employment.
Yes. Now, in regard to them, were major concessions made, and you sat in that inquiry.
It will be difficult for me to confirm whether they had made any concessions that were of any significance or not. I can tell you how we then tie up the proceedings, as was the case at the time. Questions we had never seen before were put to the witnesses. We were not allowed to participate by asking questions of clarity or asking questions to the witnesses and so forth. And this is why we immediately made the point that we would wish to be placed in possession of the report when it becomes available, particularly where it refers to the testimony or otherwise of the PRASA officials, because we would have had to then take instructions from our client thereabout. Now, the arrangements with the commissioner was that we as PRASA's legal team should facilitate some communication between the PRASA officials who testified and Mr. Makenza Mabunda, who I believe represented TCI, in order to establish whether there would be any agreement that may lead to either settlements or resolution of the matters. We then were engaged in numerous consultations with the same officials about what we understood the liquidations inquiry or commission to have been about. And there are reports that I filed that I refer to in my affidavit that confirm that we could not come up with any information which necessitated that we consider looking at the claims in the arbitration differently from what would have been the case before the liquidations inquiries.
So in effect, when you look at what happened at the liquidation inquiry, then you had these consultations, and the idea, as I understand it, at the liquidation inquiry was that Mr. Mabunda and these individual employees will get together to see if they could reach some figure
That is,
as to what PRASA is owing.
that is correct.
You then wrote to the commissioner. Is that correct?
Correct.
And what was the thrust of your letters?
The thrust of our letters would be that we could not establish any facts that would have necessitated that we engage, or our witnesses engage with Mr. Mabunda with a view to with in mind perhaps to establish whether there could be some agreement on the amounts still owed, if amounts were still outstanding, and or that a settlement be looked into seriously more than may have been the case before. We as a PRASA's legal representative could not find anything that suggested that.
That the case that you had pleaded was a weak case.
That the case that we had pleaded was a weak case. I can give an example so that we get to we get somewhere in understanding what was before us at the time. When I was going through the report, you may have picked up that, for example, we would say that PRASA is not liable because there was no authority for PRASA to enter into such arrangements as may have been pleaded. The witnesses may have been interrogated on the same works that we as external legal representatives are disputing that were authorized. So we won't be talking at the same level when I'm defending the matters by raising, for example, defenses like ultra vires or lack of authority, when the commission was dealing with whether those services, as may have been disputed by us already, were rendered or not,
So it was
or whether
asking
the
a diff-
invoices,
Oh, sorry. Carry on.
or whether the invoices it may have been an issue that dealt with whether invoices were submitted in return for services rendered, when our case was the invoices as presented to us are not in consonance with the annexures or the schedules that describe precisely what the services should be. So once again, without having had the benefit of what value the report carried in as far as the alleged concessions were made, it was almost impossible for us to make do of anything that may have had to do with the inquiry itself.
Then at paragraph 9.1, the chairperson says, that she will contact, she needs a report from you on the defense strategy. Could you just indicate what she says specifically? Paragraph
Yes, Dr.
9.1.
Paragraph 9.1 says, I will only and if absolutely necessary and appropriate involve former employees that testified after receiving a report from you and Ms. Ngoye, as well as Mogashoa Diale attorneys on your defense strategy, particularly in view of the concessions by current employees during the liquidation inquiry.
And then she says at paragraph 10 that you should be advised what was going to happen next. And what was that?
It says that please advise Mogashoa Diale attorneys that I have read their report dated 21 November and that we shall revert to them before the end of the week, of next week rather, with instructions and a decision of further handling of this matter.
Now, did you receive instructions on the further handling of the matter?
What transpired after perhaps the conclusion of the second report?
Well, before we get to the second report,
In the context of what she says here, we never received any further instruction, particularly in respect of, or with respect to what she says in this report. And I think I deal with that in the affidavit.
yes. Now, in regard to this report, her memo of the 28th of November, did you prepare a second report?
Yes, subsequent, as requested by Mr. Dingizwayo, our firm prepared the second report.
And is that the one marked MN7 and appearing at page 356 of bundle E1?
Correct. That would be the report.
Before we go into the report, though, I just want to ask, because this, in a sense, was intended as a response to what the chairperson had raised in her memo to Mr. Zide. Is that correct?
Yeah, this report will speak to those areas that involved our firm. And I think that is what legal, through Mr. Dingizoyo, asked me to do.
If you look at paragraph 1.1 of MN7, that's what it says, is given that the report was made available to us yesterday, we can only accept the data, well, but that is the report that you are responding to.
Correct.
Okay. Now,
I'm sorry, Mr. Sonny. I think I was still focusing on something and you may have moved on to something else. I note that in the chairperson's memo that you have been dealing with, she says in paragraph 9.1, I will only and if absolutely necessary and appropriate involve former employees that testified after receiving a report from you and Ms. Ngoye, as well as Mogashoa Diale attorneys on your defense strategy, particularly in view of the concessions by current employees during the liquidation inquiry. Now, that this might not affect Mr. Mogashoa, but I raise it because it may be important in relation to her dealings with the legal department, because it seems that as at the date of this memo, she is still asking Ms. Ngoye, among others, to submit reports about what she refers to as their defense strategy. And of course, she refers to Mogashoa Diale attorneys as well, in relation to the question of her or of the allegation that she excluded the legal department, it will be important to try and establish from when did this alleged exclusion happen? Because at this stage, she's still wanting to involve the legal department, at least in regard to the report. I think that it may be that in regard to giving instructions to the attorneys, she may be saying those must be given by the acting CEO. So I thought I must mention that we'll need to try and establish from when did the alleged exclusion take place.
Yes.
Yeah.
I'm going to deal with that next, Chairperson.
Yes, okay. And of course, in the last paragraph, she does say the reports from you, that's paragraph 12, the reports from you, Ms. Ngoye, and the officials indicated in paragraph 9, that's the paragraph that I was talking about, must reach me on or before 12 o'clock on Friday, 13 November,
Yes.
to enable me to report to the Board of Control on 1 December.
Yes.
Okay, so there will be the question of whether, apart from the report from Mogashoa Diale attorneys, whether there was a report from other people that she mentioned in the memo.
Mr. Mogashoa won't know that.
Yes, no, I'm just mentioning it for
Yes.
some other time.
I would just, that's a matter that's dealt with by Mr. Dingizwayo, where
Yes.
he, on the 30th, submitted
Yes.
a report
Yes.
in response to this request for
Yes.
the report from Ms. Ngoyi.
Okay.
I suppose because he was dealing with the matter.
Yes, okay, so no, that's fine. I seem to remember a memo from him or report that went to the acting group CEO,
Yes.
but was meant for the acting group CEO to pass it on, I think.
On to the chairperson.
Yeah, so it's just important to link these two.
No, absolutely.
Yeah,
But to come back to the question, I'm going to raise it in the context of what happened after this, Chairperson,
Yes,
if
yeah.
I could.
Okay.
Now, after you submitted this report, I can say this report meaning the report of the 30th of November, that's MN7, what happened next in so far as your dealings with PRASA went?
I think what happens next, according to my affidavit, is I was then called into a meeting at PRASA. Let me just see exactly where I deal with that.
At paragraphs 24 to 27, Mr.
are you back to his affidavit?
To his affidavit, sorry, yes, Chairperson. That's SS 13 in bundle G.
Yes, and what paragraph are we now?
24 to 27,
24 to 27.
yes, at page 10, Chairperson.
Okay.
Would that be correct, Mr.?
That'll be correct, yes. That's what happened next is what I say in paragraph 24 of my affidavit.
So let's, unless you want to read it, could you explain to the Chairperson what happened on the 4th of December?
Maybe before we do that, and I may have missed this, can we deal with what was different in their report of the 30th of November to 2017 compared to because the earlier report had been done about, 10 days before?
Yes.
Yes. And what issues did it seek to address?
No, sure. So, sorry, can we go back to Ms. Ngoyi's affidavit, MN7,
Which page?
at page 356? This is your report of the 30th of November.
35. Oh, I'm on it.
Right. So you then indicated paragraph 2 that at paragraph 1.6, you deal with the fact that you had received the chairperson's report. I take it off the 26th of November, is that correct?
I think it's 28th of November.
Yes.
That's correct, yes.
And then you deal with the questions that she had raised in that memo.
Correct.
Okay. The first question is the litigation and the voluntary, the litigation and the liquidation. In other words, which came first? You recall she had asked that.
Yes.
And in essence, what do you say?
I see. I will just summarize the paragraph.
Yes,
Start going
yes.
through them in detail. Well, the introduction that I give there is the fact that we had received instructions from PRASA between 2015 and 2016, and that my opponent is, or was at the time, Mr. Matopo Atenis. We summarize what was pleaded, or we make reference to what was pleaded in the various sets of particulars of claim. And then I make reference to a letter marked Annexure A, that makes reference to communication between the parties in respect of the need for the matters to be consolidated, and that we consider referring the matters for arbitration. I confirm there on paragraph 2.3 that Judge Brand was appointed as the arbitrator in the proceedings.
And then at paragraph 2.6, you say that those had been adjourned to the 26th to the 29th of March 2018.
Yeah, but there were dates in September of 2017.
Well, the dates were in September, were 11 to 22 September 2017.
Yes,
That
11.
appears at paragraph 2.5 of your report.
Yes, yes. So,
And as at that time, that is now, as at the beginning of December or end of November, it appears that the matters, the arbitration, was set down for certain dates in March 2017.
correct. This then means that I think around the time we're dealing with the liquidation inquiries, there was a problem with the issue of readiness to proceed. And I think we deliberated and discussed it between the parties, and I think Advocate Tsatsawani may have been instrumental in dealing with Advocate Bottas about...
But the long and short is,
The long
it
short
was
is
postponed
postponed.
to March
It was
2018.
postponed to March 2018
Yes.
for a variety of reasons, yes, correct.
All right. Then in paragraph 3, you deal with the section 417 inquiry, and you make the point in paragraph 3.1 that you do not have the interim report.
Yes, that's what I say in paragraph 3.1, that we do not have a copy of the interim report.
Yeah. And you then comment on the fact that the chairperson had been approached by the attorneys of the other side. And what do you say about that?
Is it paragraph 3.2 now?
No, 3.1 still.
Right. I say it is surprising that our opponents have gone on to do so, and that they went on further to hand over documents to the chairperson, which documents purportedly carry some weight in enabling the parties to assess the claims properly.
So what were you referring to there?
I was referring to the interim report.
Yes. And the fact that the chairperson in her memo had said that she'd been approached by the attorneys.
Correct. The attorneys for the other side.
For the side,
Yeah,
yes.
correct.
All right. Now, do you make the point that you do not have the report?
Then I make the point that I think despite numerous attempts at getting a copy thereof, I still did not have it at the time of finalizing this memo.
Yes. Then, in the rest of paragraph 3, you set out more or less what you've set out earlier about what had happened at the liquidation proceedings.
Correct.
And then at paragraph 3.11, you respond to the assertion by the chairperson that what you had said may not be entirely correct. And what was your response to that?
We're saying in paragraph 3.11 that to date, our office has not been placed in possession of any or all of the documents that may have been made available to the chairperson of the interim board. To this end, it is not certain to us under what or which context the chairperson concludes that these assertions may not be entirely correct.
Right. Then in paragraph 4, and particularly 4.1, you deal with the question of what the effect of the concessions, what effect the concessions might have on PRASA's case. What do you say about that?
We say there that although it has been PRASA's position that it is not liable to CIA in spite of the proceedings of the inquiry, we at this stage submit that it would not be possible for us to comment on how the alleged concessions made would now affect the crux of the defenses as pleaded in respect of each and every one of the defendant matters. We would need to have sight of the relevant documents that may have been given to the chairperson, including the interim report.
Now, were you ever given those documents, the relevant documents that you talk about?
I was never given any additional documents, no.
So that's the report that you sent on the 30th in response to the chairperson's memo of the 28th of November.
That's correct.
I see that in paragraph 3.2 of your report that you have just dealt with now, that you and Mr. Soni have just dealt with, you deny a statement made in the PRASA chairperson's memo in paragraph 5, where she says that, if I understand, you understand, yeah, where she effectively says that your firm, in your report, that is the first report, I take it, no, I may be mistaken, because they also attach copies of email communication between Mr. Madimpe, or that is the attorneys for CIA, who she is talking about, where she says they also attach copies of email communication between Mr. Madimpe Mogashoa of Mogashoa Diale and Advocate Francois Portes SC. The email communication is also attached in Mr. Mogashoa, in Mogashoa Diale attorney's report. Or she says that email communication is also attached to your earlier report. You seem to respond to that in paragraph 3.2, by saying we would also like to clarify that our previous report of 21 November 2017 did not attach any of the email communication between our Madimpe Mogashoa and Francois Bortes, and neither did the report make reference to any such communication. We will later in this report, however, append here to the relevant communication as may assist in clarifying some of these issues. So, do you confirm that in your first report, you did not attach any email communication, such as the email communication that the PRASA chairperson says in paragraph 5 of her memo you had attached?
That is correct, Chair, and I think in paragraph 3.2, we just wanted to clarify that.
Yes. So if she got any such email, it certainly was not from you.
They were not from my office,
Yes.
correct?
Chairperson, if I could put it in context, you will recall that attached, annexed to Mr. Botis's affidavit is the liquidator's report and the email communications that the chairperson is talking about. So
Or is she, maybe she could be saying, she might not be saying the email communication was attached to their report.
Yes.
But she might be saying the email communication between them and either Mr. Portes or CIA attorneys was attached to that report.
to that report.
Okay.
Because that's the report she received.
It's
from
just
Mr.
that last line of paragraph 5 of her memo says the email communication is also attached in Mogashoa Diale attorney's report.
With respect, she does in fact say that.
Yes.
But
So what I was seeking to confirm is whether that's factually true, because I read paragraph 3.2 of Mogashoa Diale's attorney's second report as denying that.
Yes.
Is my understanding
Yes.
in line with yours?
yes, it is so.
Yes, and Mr. Mogashoa, you confirm that to the extent that she says in her paragraph 5, to the extent that she may be meaning that in your first report you had attached such email communication, you say that's not true.
Correct, Chair.
I was trying
Obviously,
to
if she means something else, that's different.
No, sure.
Yes.
I was just trying to make the point that there is no dispute
Yeah.
that she received it from Mr. Boat,
Yes.
because that
Yes.
Mr. Boat says so
Yes.
in their meeting of the 14th of November.
Yes.
He handed her the report
Yes.
plus those.
Yes. Yes, but
so-
of course, she says this email communication was attached to their report.
Yes.
And their only report she could be talking about at that time is the first report.
First report.
And Mr.
of the
Mogashoa
26th.
says that's factually not true.
That is good. Now, you say...
I see that we have gone past 1, but I would like us to finish, if we can. I thought we would finish before 12 or around 12, but the matters we have dealt with are important.
Yes.
But I think we should be able, I don't know what your own assessment is in 30 minutes' time or so.
That's my assessment.
Yes. So let's continue.
Yes.
But if anybody needs a comfort break, we can take that. But if we can move on and try and finish by 30:30, let's do so.
Yes.
Okay.
Now, on the 4th of December, if we could just summarize these aspects, please, Mr. Mogashoa. What happened on the 4th?
Right, on the 4th of December, I got a call from Mr. Zide, whom I believed was the acting chief executive officer of PRASA at the time? You
Speak
can't hear me?
closer to the mic again.
Okay.
Yeah.
Apologies about that, Chair. I received a call from Mr. Zide, who indicated to me that the chairperson, Ms. Makubela, wanted to see me about issues related to this group of matters. My colleague and I, Ms. Mbebe, and I went to PRASA's offices. I imagine it was during the same day. We were
Okay, at
received-
paragraph 25, you say what the purpose of the meeting was. What was the purpose of the meeting?
Correct. I say there that at the meeting, the chairperson raised concerns about the fact that my firm was involved in formulating responses to her memo of the 28th of November, when she, in fact, had wanted the group CEO to respond, and perhaps with the assistance of the internal legal department, and that certainly.
No, but sorry, Ms. Mogashoa.
Yes.
I understand you are making a different point. If you read paragraph 25, her unhappiness stemmed from the fact that it was distributed to you.
Correct. I think I'm saying the same thing.
Okay.
Yes, that she expressed some discomfort at the fact that the memo was distributed to me.
Okay, now in regard to that memo, what did she want?
She did not say anything further than the fact that she expressed unhappiness about the fact that the memo.
Well,
had
if
been
you look
given
at
to me.
the rest of paragraph 25, you say she wanted you to hand the memo back.
Yes, I can finish my point around that.
Okay.
So she expressed unhappiness about the fact that I had been given the memo, and that she is aware that there may have been a report that I prepared in response thereto, and that she was not interested in that report. She asked that I hand back the memo, but I made the point that I had received the memo electronically, but if she wanted our firm to discard with the memo, we would do so when we get to the office.
Okay. Now,
I'm sorry, Mr. I see that you say that in that paragraph, you say that she said she was not going to accept your report of 30 November 2017 that responded to the memo, to her memo, insofar as your firm was concerned, given that her memo was not meant for you in the first place.
Correct.
Did she say that?
That's what she said to us.
Is your recollection quite clear?
My recollection is quite clear.
Didn't that surprise you?
Well,
Given her memo, even though it may not have been meant to you, because in that memo, we just had a look, she wanted a report from a number of people, but those people included yourselves.
Yeah, but if you look at the memo, Chair, if you look at the memo, although she makes reference to our firm, in as far as some of the issues she was grappling with may have been concerned, her point to me at the meeting was that the memo was meant to be dealt with internally, and that she did not understand why legal thought it fit to pass on the memo to me to speak on, even if it's on the very same issues that perhaps concerned our firm at the time.
Well, I just want to check, because my understanding, and I think it was paragraph 9, no, it's not paragraph, yeah, it was 9. She says, I will only, and if absolutely necessary and appropriate, involve former employees that testified after receiving a report from you and Ms. Ngoye, as well as Mogashoa, the other attorneys, on your defense strategy, particularly in view of the concessions by current employees. You saw this report, even though she said it shouldn't have come to you. What was your understanding of this paragraph? Or have you no recollection of how you understood it at the time?
I understood, Chair, that legal was looking for assistance from my firm in as far as explaining, perhaps with more detail, what the liquidations proceedings were about, and what we made of them as PRASA's legal representatives, which request by legal I did not suspect was untoward. We had given them the first report. If more detail was required around issues to do with the liquidation inquiry, that's what I thought legal would have wanted us to assist them around. But at the meeting, fine, she took the point that the memo was not meant for a firm, and then in that respect, we did not even have to discuss the memorandum of the 30th of November, because her position was the memo was not meant for us. So that report we had drafted, we were not supposed to have drafted in the first place.
Of course, did your report of the 30th of November deal with what she called defense strategy? Because it seems that's what she wanted Ms. Ngoye and your firm to deal with in terms of paragraph 9. But again, she was saying, I will only, and if absolutely necessary and appropriate, involve former employees. So I think she was saying, if I am to involve former employees, I first need to have a report from Ms. Ngoye and Mr. Zide and PRASA's attorneys, Mogashoa, the other attorneys, telling me what the defense strategy is. Is your understanding the same as mine on what she was saying?
It is. The only thing is, up to that point, the only request I had received was from legal to comment on those areas of her memo that concerned our firm.
No, I will come to that. I just want to check. Is my understanding of what she was talking about the same as yours in that paragraph?
It will
Namely,
be, Chair.
if she was to involve former employees, she would need a report from Mr. Zide, Ms. Ngoye, and Mogashoa, the other attorneys, on what the defense strategy is. We are on the same page.
We are on the same page,
Yes.
correct.
Now, were you asked by either Mr. Zide or the legal department of PRASA to prepare a document that dealt with PRASA's defense strategy in regard to the CIR matters?
Not at that point of
Yes.
the 4th of December.
No, not around that time,
Not around that time.
and not after, actually.
Not ever after.
Yes. Okay, all right. And just to confirm, your report of 30th November did not deal with that. We did not deal with the defense strategy that she was talking about.
No, it did not.
Yes, okay. Mr. Sonu?
As you please, Chairperson. And then she pointed out that she was not going to look at the memo of the 30th of November that you had prepared.
Yes, that's correct.
And
I think if we call it a report, let's be consistent.
No,
Otherwise, somebody who read this transcript after some time will think there is also a memo of 30th
Yes.
November
No,
and a report of 30th November. Okay.
Now, forget the fact that the memo, her memo of the 28th was not meant for you. You take the trouble, having received instructions from legal, to prepare a report.
Correct, that's what happened.
And I think that's the point the chairperson is making, that the board chairperson now says, I'm not looking at it. Did that not surprise you?
I was surprised.
Right. Then,
I'm sorry. If we take it that she was not interested in your second report, and that therefore she did not look at the report, are you able to say what perspectives or knowledge she deprived herself of in regard to understanding this matter better? Or would you not be able to say? Because your report would have dealt with certain issues, and I take it there would have been a need for such issues to be clarified, given that you had just prepared another report.
I took time under serious constraints to prepare the second. And for me, in the context that I understood her memo to have been asking for a bit more information, I thought that would have been information relevant to some of the inquiries she had made, albeit that she did not expect that I would add to her memo. But I thought they were relevant submissions to bring anyone on board about or regarding the issues that were confronting all of us in respect of the CII matters.
and from the PRASA side, only you and council had attended the Section 417 inquiry. Would that be correct?
It will be my team, meaning Ms. Mbebe and myself and the council team, and of course the officials of PRASA, or from PRASA that had received subpoenas to us.
Yeah, but they were witnesses.
Yeah, they were witnesses. Otherwise it will be just us. Ms. Mukotedi may have come for a short period, either on the first day or the second day that we appeared. But she came very briefly, and I could be wrong in suggesting so. But she may have come through to join us for a while.
Now, in regard to the interim report of the insolvency inquiry, what transpired or what discussion transpired at this meeting of the 4th of December?
At the meeting of the 4th of December, I do not believe that we got to the details of that report. I think what I was then told by the chairperson was that the board would take a view on how to proceed with these matters, and if needed, what our firm's further involvement would be.
Did you explain to the chairperson the disadvantage you were under as a result of the fact that you didn't have the report?
The discussions did not go that far, given the fact that she did not want to get into the details of my report of the 30th of November.
Did you tell her that you had not seen the interim report?
Let me just refresh my memory, because I think paragraph 26 says something of my affidavit about the report.
If you look at the third line from the top, from the bottom, I made the point.
All right, then it means she mentioned the report, and I'm saying I made the point that I did not have the report she was referring to, despite that I may have called for it prior to to our meeting. She voiced out concerns about how PRASA was now going to deal with the report and the arbitration proceedings, which at the time had been postponed to March, given the evidence of the employees of PRASA.
Right, and in the last sentence of that paragraph, again, 4 lines from the bottom, you start off with, I made the point.
I made the point to Ms. Makubela at the meeting that it was not going to be possible for me to comment on her concerns without the benefit of having seen the contents of the interim report and the insolvency inquiry myself.
All right, how did the meeting close?
I think as far as I
Maybe before it closes, I'm not sure that you have dealt fully with this issue of the interim report in terms of what transpired between you and the PRASA chairperson. And I realize you needed to refresh your memory. Do you want to just to tell me again, how did the interim report come up in the conversation? What did she say? What did you say? If you need to refresh your memory, you may refresh your memory, but I just want to hear fully what transpired at that meeting.
Okay, at the time I was dealing with this issue earlier, I was under the impression that the report was discussed at the next meeting that followed. But I see that paragraph 26 and maybe into 27 makes reference to the fact that she raised the issue of the report at the meeting. I indicated that I had not seen the report. I was never placed in possession of that report, and that therefore it was going to be difficult for me to make any comments about the value that and the weight that the report carried in the context of the litigated matters before the arbitration that had been intended to follow in March of 2018, and that I had nothing more to offer her other than that perhaps if the report were to be availed to me, then I can act on it and consider it and do what would have been necessary for me as as PRASA's legal representative to do, given the contents of the report. And I think it did not go any further than that, except that, but that I must point out that we then were told as a firm that that PRASA will revert back to us as soon as she has some idea about what PRASA's attitude is towards the report and the matters in their entirety.
Was this your first meeting with her in regard to PRASA matters?
It was my first meeting with her, yes, on the 4th of December.
Okay.
As you please. Now, who all was present at that meeting?
It was myself, it was Ms. Mbebe from our office, it was Mr. Zide and the chairperson, Judge Makube.
Okay, so would that mean that nobody from the legal department, but particularly Ms. Ngoi or Mr. Dingizwayo, was present?
They were not present at that meeting of the
Did that
4th of
surprise you?
Well, yes, it did. It did surprise me that they were not part of the meeting.
I take it from what you have said about what transpired at that meeting that you did not expressly ask the PRASA chairperson to let you have a copy of the interim report.
I did put it to her that it would be helpful that I be placed in possession of the report.
Yes.
Yes, I did.
You did put
say
it that way,
in
yes.
the meeting.
Yes, and did she then offer you a copy of the interim report?
Not at that stage. I was told that PRASA will get back to us
Yes.
as a firm on what the decision is in dealing with the matters
About going forward.
So at that point, I did not receive, or I was not given a copy of it.
Yes. Okay.
So did you get the impression then that this decision was going to be made without any further input from you?
Well, you can accept that at that point, Chair, I was not aware what decisions PRASA was likely to make. I was told that I would be contacted as soon as there was some idea regarding what to do with either the report or the matters, and that is precisely what happened thereafter.
It's quite clear from what you have said in regard to, I think, that meeting, but also in regard to the PRASA chairperson's memo of 28 November, that she believed that certain employees of PRASA had made major concessions with regard to the CIR claims. And it would seem that she was, she implies that what she regarded as major concessions made by those employees would play quite a significant role in the decision about the way forward. That's the impression I get from her memo and from what you tell me. Is that an impression that is the same as the impression you had then, or not at that stage?
That's the impression I got, that she was worried about what leg then PRASA would stand on in further continuing to defend the matters, given the contents of the report. And this is why I repeated on many occasions that without the benefit of the interim report, there could not have been any more that our firm could say other than to accept that there is a report in existence somewhere.
And of course, in her memo of the 28th of November, she specifically made reference to requiring to be told by Mr. Zide, Ms. Ngoye, and your firm what the defense strategy, what PRASA's defense strategy was to the CIR claims. Is that right?
That is indeed so.
But she did not, at the meeting of the 4th of December, as I understand your evidence, say to you, what I would like from you is to tell me either now or to furnish me with a document that tells me what your defense strategy for PRASA is. She did not say that, did she?
No, not Chairperson, no, she did not say that.
At the meeting of the 4th?
At the meeting of the 4th.
Yeah, and
I was not asked to make any further representations about my impressions of
the defense.
Of the defense, with or without the report or the interim report of the commissioner.
Yes.
I was not asked to make further representations around that.
Yeah. Okay.
Just one final question on the persons who were present. Did Ms. Makubela ask at that meeting, ask Mr. Zide where the members of the legal team were?
Not to my recollection. If she did, perhaps I was not there.
Not during your presence?
Not during my presence.
Oh, okay.
All right.
Were you told anything about why they were not there?
No, nothing was explained to me, but you would see that in paragraph 27 of my affidavit, I do say that I called them immediately thereafter because I had to, it was the first time that I was interacting on the matter at PRASA with PRASA officials other than them. So I called them to say to them, That's the meeting. The chairperson is not happy about the fact that our firm was asked to comment on the memo, and that I was told that PRASA will get back to me in due course.
Yes.
Then there was a further meeting between you and Ms. Makubele.
Correct.
And when was that?
I think we do deal with that. On paragraph 28 of my affidavit, I make reference to the fact that on the 14th of December, I received a call from Mr. Zide, who indicated...
I'm sorry, Mr. Soni and Mr.
As you please.
Just looking at the last part of your paragraph 27, when you told Ms. Ngoye and Mr. Dingiswayo and Ms. Mukoteti about your meeting with the PRASA chairperson and Mr. Zide on that day, did they say anything about their absence at the meeting? Or did they seem to know about the meeting at all? Or is that something you can't remember?
It's something I can't remember, because I think I placed emphasis on reporting back to them that the chairperson was not happy.
Yes.
And that I was informed that the members of the group legal then would have to explain to her what happened, much as I was told at the meeting that PRASA will get back to us as a firm, should that need be there.
Yeah, okay.
All right, then the next meeting, you say, took place on the 15th of December.
Yes, I got called on the 14th.
By whom?
Mr. Zide, that the chairperson wanted a meeting with us on the CI matters the next day.
All right. Now, did that meeting take place?
Yes, the meeting took place on the 15th. I did not state the time because I can't remember what time the meeting was. And I think present at the meeting was the chairperson, Mr. Zide, and myself. I can't remember that anyone else was there.
Okay. But certainly not Ms. Ngoyi and Mr. Dingiswayo.
Certainly not Ms. Ngoye or Mr. Dingiswayo.
Did Ms. Makubele ask Mr. Zide where Ms. Ngoyi or Mr. Dingiswayo were at that meeting while you were there?
If there was ever that conversation, I don't have any recollection of it.
And if it had taken place, would you have remembered it?
I would have, perhaps. I imagine so.
Okay. Now, anyway, at this meeting, if you could just briefly summarize what happened there.
All right, I got called into the meeting, got onto the meeting with my files, and by my files, I'm referring to the two reports, because I thought that the meeting would be about the two reports that I had prepared. I think two key things were tabled as agenda items. The first one was that after having given regard to a variety of issues and factors, and in particular the evidence as may have been contained in the interim report, that PRASA's attitude was that there be some attempt at settling the matters, and we then went into the. I must then obviously at this point say that, well, if those would be PRASA's, if that would be PRASA's attitude, I would accept it. But I made the point further, I think at that meeting, that I do not know. I wouldn't know what the considerations are, given the fact that still at the time I did not have the report or the interim report, but that I would accept PRASA's position if it now prefers that it settles the disputed matters with the CIR group. We then got into some bit of detail on what PRASA thought it wanted to do, and this is through, obviously, the chairperson and Mr. Zide. I speak about it on paragraph 31, subparagraphs 31, 1.
Well, before you go to paragraph 31, please go back to paragraph 29.
Yes.
You were told that, well, were you told who would be dealing with the matter from now on?
All right, when I said two issues, Chair, earlier on, one of the issues that was raised was that I then would have to accept that the matter was no longer the responsibility of legal and that the board was now seized with the responsibility of dealing with the matters further. I was given instructions that from that point onwards, I would have had to deal with Mr. Zide. I can't remember whether at the time he was still the acting group CEO or he had reverted back to his original position of the company secretary. But I was told that the matters will be dealt with by the board and communication to my office will be through the office of Mr. Zide, and that at that point I was advised that there was no need then for me to continue discussing the matters with members of the legal department.
With regard to Mr. Zide's position at that time, and you don't need to go there, Ms. Ngoi in her affidavit says that Mr. Zide from the 7th was no longer the acting CEO. Mr. Malope became the acting CEO, and Mr. Zide reverted to his earlier position of chairperson of the board. I'm just placing that.
Oh, yes, oh, yes. But the instruction was that whatever communication between our firm and PRASA would be through Mr. Zide and Mr. Zide's office.
Now, in regard to the fact that you were no longer to communicate with PRASA Legal, what was your reaction to that? Not expressed necessarily, but I'm just saying your personal reaction to it.
Well, perhaps let me respond by saying that it is not unusual that we receive such instructions in our firm, given the profile of some of the clients we have. So it has happened before that the CEO of an institution would request us not to deal with legal, perhaps because legal was the subject of whatever investigation we had to carry out. It is not unusual for the board to consult with us and provide us with instructions to that center around investigations of a CEO of a company. So to that extent, and when I was told that the board has decided to take responsibility for such matters, I was not overly perturbed by that instruction. It was followed by another instruction that the communication should happen through the company secretary. It's not unusual that company secretaries would carry that or such responsibilities as may be required by the board. So in that sense, I was not overly perturbed by the chairperson's position that the matter was now in the hands. The matters were now in the hands of the board, for the board to deal with.
Actually, you are not perturbed at all.
I was not perturbed at all, yes, correct. Correct, Chair.
I just noticed you were saying not overly perturbed, but I thought your explanation must mean you were not perturbed.
I was not perturbed because we do receive such instructions from the institutions we carry work out for from
Yeah.
time to time.
Would you get to know in other instances why, for example, the legal department why you would be required not to communicate with the legal department or to get instructions from them, but rather the CEO? Or would you just be told, be told that from now on, it's the CEO's office that will deal with you, without being told anything else, like, well, there are some investigations about concerning the legal department or anything like that?
Well, other than that, there would be,
Some explanation? Or,
well, or that whatever investigation or instruction related to a member or members of the legal department or the head, for that matter.
yes.
We then find ourselves dealing with other functionaries other
Yeah.
than legal
Okay.
in such, and we do understand that.
Yeah, okay.
So, some of the matters we would do on behalf of boards would be matters that have to do with,
Yes.
with boards, and
Yes.
they may contain information that relate to functionaries which the
Yes.
board did not wish that the functionaries gain access to, at the very least through us.
Yes.
So
So
we,
it does happen?
it does happen.
Yeah, okay.
But this was unusual, and I'm going to suggest to you why. Immediately after the meeting, you phoned Mr. Dingizwayo and told him about that instruction.
Yes, immediately after the meeting, I called Mr. Dingizwayo and I mentioned to him that I was told that the matters now are in the board's hands and that there was no need for me to be discussing them further with legal.
So I'm going to suggest, Mr. Mogashoa, that that's quite different from the examples you've been giving us. You're told don't consult with, don't talk to them. But that's exactly what you do. I'm asking then about your reaction to that instruction.
Maybe before that question, let me get clarity as to what precisely the chairperson told you with regard to any further dealings between yourself and the legal department of PRASA. At one stage, I think in your affidavit, you say something to the effect that she said there was no need for you to deal with the legal department of PRASA or to take instructions from them. But I think elsewhere you put it more like an instruction. Now, if she says there is no need, it might not be an instruction not to deal with them. It might simply be that you won't have to get instructions from them. You'll now get the instructions from us. So if you talk to them, I don't see any need why you should talk to them, but I'm not saying don't talk to them. But if you say it was an instruction not to talk to them, then it has a different connotation. Precisely what was it? What did she say?
Just to assist you, Chair, it was an instruction, and this is precisely why I contacted Mr. Dingizwayo.
Yes.
I contacted him for two reasons. The first being that I wanted to manage legal department's expectation of me telling them what further instructions I have from the board. And secondly, because I, at the time, was dealing with many others of their instructions, I did not want to find myself in a difficult position where we now get into discussing the CI matters. When I had been given an instruction not to discuss the CI matters with them, and we so I don't know what I've done here, and we continued to interact on other matters or in respect of other matters without necessarily getting into the issues to do with the CI matters.
Well, that's important because I meant to ask you later on whether the CI matters were the only matters you were handling on behalf of PRASA or whether there were other matters. From what you have said now, it seems that there were other matters on which you had instructions from PRASA other than the CI claims.
Correct, Chair. There were other matters that I was dealing with.
Are you able to say it was 2 or 3? Or are you able to say it was a number of them?
It was a number of them.
Yes.
I was doing quite a fair number of
work
litigation
from-
matters on behalf of PRASA
Yes.
Corporate.
You might not be able to be precise in terms of the number, but are you able to give an estimate more or less 10, more than 10? Or?
There may have been at the time 6, 7 or 8
Matters.
other unrelated,
Yeah, that's
Matters.
apart from the CIA matters.
apart from CIA,
Yes.
that were in arbitration
Yes.
forums or
Yes.
that they were litigated out of the High Court.
Yes.
And mostly we acting as defendant.
Yes.
can't
So
imagine
PRASA
what
had
else.
been sued.
PRASA was being sued, correct?
Just for the sake of completeness, did the PRASA chairperson at any stage ever interact with you in regard to the other matters you were handling on behalf of PRASA other than the CIA claims?
Not to my recollection, Chair. I think to assist you further with your question, I do not believe that I have, since the meeting of the 14th, that I had any further interaction or engagements with the chairperson of PRASA.
Yes, but I'm also asking even before that meeting of the
No.
14th, whether you had any interaction with her with regard to claims against PRASA that you were handling on behalf of PRASA other than the CIA claims.
I was called to come and discuss with them only the CIA matter.
Only the CIA claims.
Correct.
The other ones that you were handling were also pending in either court or arbitration.
Correct, that is indeed so. Some of them are still very much alive to this day.
Yes, okay. Thank you. But going back to the earlier question, are you quite clear in your own mind that what she gave you in that meeting was an instruction not to discuss with the legal department, not to discuss the CIA claims with the legal department of PRASA? Are you quite clear? Is your memory quite clear on that?
My memory is quite clear. I called Mr. Dingizo. I see Mr. Dingizo speaks about it in his own affidavit.
Yes.
But if you look at the fact that our firm then strictly started communicating with the office of Mr. Zide only,
Yes,
that as well would
yes,
confirm that the instruction to me was clear,
yes,
that I should communicate with only the office of Mr. Zide,
yes,
or through the office of Mr. Zide,
yeah, okay.
if I may put it that
Mr.
way.
Sono.
Please. What was Mr. Dingizwaya's reaction to that communication? That, look, I've been instructed not to talk to legal.
He was surprised. We did not have a lengthy discussion, but he was quite taken aback by my having said to him that the chairperson has instructed me to deal with the board through Mr. Zida's office only.
Right, then at paragraphs 30, 31, and, paragraphs 30 and 31, you make the point that at the end of the day, the chairperson again raised the question of the 417 inquiry, the adverse effect it would have on PRASA's prospects of successfully defending, and then you say that you were told to settle 4 of those claims.
Correct.
Is that what happened?
That is what happened. Yes.
Now, I'm not going to go into the settlements now because you later on say that there was a written instruction on precisely how the matters were to be settled. We'll come back to that. Then at paragraph 32, you make the point that you were given an instruction about how the settlement agreements were what to include in the settlement agreement.
I'm sorry, Mr. Sonny. You said you are going to skip these settlement agreements because later on he talks about a letter.
Yes.
But is it not better to deal with it because now in 32 he's talking about a clause that was meant to be in the settlement agreement or the issue of confidential, but we don't know yet that he has been instructed. So I think logically we should hear that he gets instructions to settle on whatever terms and then.
As you please.
Yeah.
So in paragraph 31, you set out the manner in which you were to settle each of the 4 claims that are mentioned there. Is that correct?
That's correct.
All right, let's look at 31.1.
I'm sorry. Are you still at 31 dealing with what transpired at the meeting of the 15th of December? It looks like. Are you still in paragraph 31 dealing with what transpired at the meeting of 15th December?
Correct, Chair.
Yes, okay. Okay, to deal with that.
So at this meeting now, you are told that 4 of the matters are to be settled, and you are given the figures at which you must settle them. Is that correct?
I'm sorry, Mr. Soni. What did Ms. Makubela say about the settlement of the CIA matters at that meeting?
Chair, I'm not sure I follow, but
I just want to, did she say anything about the CIA claims being settled at that meeting? I just want you to tell the story.
all right. Okay, that's fine. I think I understand what
You deal
want
with
us-
it at paragraph
want me to assist with this.
30, the last part of
Paragraph
paragraph
30.
30.
And you can refresh your memory, but I just want you to relate to me the story.
All right, I think the summary, I can summarize paragraph 30 to be that the chairperson put to me that given the contents of the interim report and perhaps other factors, PRASA had decided that it will be in its best interest that it attempts to settle the matters with this group, given that she was concerned about the fact that we may not have evidence that is adequate or sufficient to sustain proper defenses in light of the fact that the interim report suggested to her that there were concessions made by the PRASA witnesses. And I think I made the point to her once again that I can't comment on the report, but I do hear what she's saying about PRASA's intention of negotiating a settlement with the CIA group for the reasons she advanced. And I said to her that our firm, as a creature of instructions, would then need to be instructed in writing about what offers PRASA wanted to make to the CIA group. And I don't want to get ahead of you, Mr. Soni.
Yes, no,
We
that-
discussed the four
amounts.
matters that PRASA said it was in a position to make offers on.
Yeah, Mr. Soni can take it from there.
Yes.
As you please, Chairperson. And then she indicated a figure at which each of the matters must be settled. Would that be correct?
She indicated figures which she thought would represent offers to be made.
So have a look at 31.1, and that dealt with which case number?
31.1 dealt with case number 47597 of 2016.
And what was the amount that was, in respect of which a tender had to be made?
The amount here is 17,178,853 rand.
Don't lower your voice.
Oh, yes,
Don't
yes,
lower your
Chair.
voice.
Okay. I may be beginning to run out of energy. But I'm still okay to continue.
Yes, okay.
And then at 31.2, what case number?
It's case number 47598 of 2016, and the amount thought of at the consultation was 15,371,739 rand, 87 cents.
And the one at 31.3?
It is case number 73933 of 2015, and the figure that PRASA thought of at the time was 8,095,950 rand.
And 31.4?
The case number is 73934 of 2015, and the figure that PRASA had in mind at the time was 7,098,481 rand, 66 cents.
So, in essence, orally now, your instructions were to settle at those amounts.
That's what I was told that PRASA wanted to do, make offers in these amounts.
And that's what that you would do in writing to the CIO attorneys.
I didn't get the question,
I
sorry.
say those offers would be made in writing to CIS attorneys.
Well, the point about that things be in writing was the point I made at the meeting, that I would prefer to be, I was just taking sketchy notes of what I was told, because I said I would act on written instructions as soon as I received written instructions from PRASA regarding what it had intended to do.
So, although this had been given to you orally, you were requiring that PRASA puts in writing what the amounts are and what the terms of the offer are.
Correct.
All right, but at paragraph 32 then, you make the point that the chairperson required a particular clause in regard to the settlement agreement.
Yes, I make the point that we were asked to include a confidentiality clause in the offers that we were instructed to make, and that such offers be made without admission of liability, given that they were purely for settlement purposes.
Mr. Soni, I know that we wanted to finish earlier, and I know that at 1 o'clock we had thought we would finish by past, but we haven't, and it's not anyone's fault. But maybe we should just take a lunch adjournment.
Yes.
Mr. Mogashoa, I see you you certainly would like us to finish before. I'm just realizing that we are at 2:00, and I think that we might find ourselves getting to 3:00 without lunch. Mr. Mogashoa, have you got a consultation set up for 3:00?
Well, I don't know how much longer Mr. Soni is of the view we will take, but I'm for my, if I were to speak for my part,
Yeah.
I'm still comfortable to continue.
Yes.
Because I would rather have us finish the proceedings so that then I can head off to Pretoria to do
Yeah.
what I still can, but I'm not opposed to
Yes,
lunch being taken.
yes,
if we
yes.
must.
No, certainly we will finish today. It's a question of whether we take the lunch now. So I think we have tried to finish so that when we take the lunch break, we don't come back, but we haven't succeeded. And it's not anybody's fault. So maybe let's take the lunch adjournment. Come back at 3:00, hopefully fresher. And then that might even assist to speed up, because I think we might all be a little exhausted after sitting from about, what, 10:30, 10:15, except for the tea break. Let's take the lunch adjournment, and then we'll resume at 3:00. We adjourn.
I'm sorry. Wayo had said that there was a secret agreement.
Yes, I remember we
And you
debated.
made the point, but it was never secret. But I just want to point out that in a sense, I suspect that's what he was talking about, that the agreement was not to be made available to anybody but the parties involved, and in particular, legal.
You're quite correct. It may have been in that context, actually.
Yes.
I'm looking at it that
I-
way for the first time.
I just
Yes.
thought, in fairness to him,
Yes.
that it wasn't as if he was making a wild allegation.
I fully understand.
All right, now, you were then waiting for instructions from them. Did you get written instructions?
Yes, I believe it may have been on the very same day, on the 15th of December,
Yes.
that I received written instructions. from
Okay.
PRASA. I think it will be my very first annexure
Yes,
as I deal with it on paragraph 33 of my own affidavit.
yes, and that's at page 21 of the bundle, of your bundle. That's MM1, am I right?
Correct. This is the one.
So these are the instructions, the written instructions now that you received.
Correct.
And they were coming from Mr. Linde Kayazite. And I see that he is signed there as Group Company Secretary.
Correct. The letter came from his office, but I suspect it was transmitted through to us by his secretary or PA, Lebogang Matsimela.
But I think the chairperson was emphasizing, Ms. Mogashoa, that the capacity in which Mr. Zide signed was as group company secretary.
Correct. I see that on page 23.
And the perhaps relevance of that is you might remember that in the earlier communication on the 28th of November in her memo, she wrote to Mr. Zide in his capacity as CEO, you might remember. I'm just taking you back to that.
I remember that.
And she made the point, as CEO, you would have given those instructions.
He made that point, correct.
All right, so now we've got Mr. Zide's letter to you, and are those the instructions you've received?
These are the instructions I received. That is indeed so, Chair.
Yes.
And were they in line with what you had been told at the meeting of the 15th of December, at that meeting where you were told about the amounts for settlement?
The amounts may differ slightly and perhaps a bit more significantly.
Yes.
In some instances. But because I left the meeting with my own written notes,
Yes,
I accept that the written instruction then represented
yes,
properly what PRASA wanted me to
yes, okay,
make an offer on.
okay. Well, it may be important for record purposes to just indicate that this letter from Mr. Zide and that in paragraph 2, he confirms that at the meeting of 15th December 2017, between yourself and the chairperson of the interim board, you were instructed as follows. So the letter seeks to, or purports to confirm what Mr. Zide believes you had been told at the meeting.
That is indeed
Is that
so.
correct?
That's correct.
And then And the first group of cases relates to CIRDP consulting engineers. And in regard to the one matter case number 74281/15, your instructions were to hold that matter in abeyance pending further instructions. Is that right?
That is correct.
Just want to point out, if you look at 31.1 on page 13 of your affidavit, Mr. Mogashoa, and keep your finger on page 22, you'll see the case number there is 479597 at 31.1.
You mean the first case?
Yes.
Yes.
All right. And you'll see that that is reflected as 2.6 on page 22.
That is indeed so.
And just like you to tell the chairperson what the amount is in 31.1.
The amount in 31.1 is 17,178,853 rand.
And the amount that you were now instructed to settle at?
It is, the amount as reflected in paragraph 2.6 of the instruction letter is 19,583,778 rand, 42 cents. But I see here,
Says
in the
including
letter
VAT.
of instructions, it says it's VAT inclusive.
In your affidavit, does it say excluded, VAT excluded?
I do not say.
It doesn't, oh,
No, I do not say.
Okay.
I think there was no such distinction made when we were in the
Yes.
meeting of the 15th.
okay.
And the other amounts appear to be the same, from 31.2 to 31.4, and the ones at 2.3, 2.4, and 2.5 on page 22.
That appears to be so, yes, the amounts seem to be the same, the three remaining amounts.
Well, was there anything unusual about the terms on which you were instructed to settle these matters in your experience, or was there nothing unusual?
I'm not sure if Chair is referring to the figures themselves or the computation.
Whatever
thereof,
it is,
or-
if there was anything you found unusual in relation to being instructed to settle the matter on these matters on these terms, is there anything you found unusual in your experience as an attorney?
Well, I would avoid talking about the computation of the figures, but it doesn't happen often that we would be instructed to stipulate in an offer we make that it carries some confidentiality. And I wouldn't be sure what the considerations were
Yeah,
at that time that PRASA thought it proper that it places such a condition on the tender itself. Although, as I say, it has happened before in some of the matters I've had to deal with in the past. That, especially if it is an offer purely to settle, or if it's an offer of compromise, that the details, especially if there are other related claimants, for example, that perhaps whose claims emanate from the same cause of action, it's not unusual or completely unusual for a defendant to want to have separate, if one may say, confidential settlements with each of the parties as the case may be. I don't get to prepare
Yeah.
tenders and say they are confidential. If it has happened,
Yes.
I can count the times.
Yes. And what was the relationship between the amounts on which you were instructed to tender to the other side and the amounts that may have been claimed by the CIA companies in their summonses? Did you take the trouble to check how they compared?
It was my observation, Chair, that the figures were more or less the same. I mean,
Yes.
you didn't have a situation where 15 million was claimed and 3 million was tendered.
Yes.
Just by looking at the figures and you compare them to what the total amount claimed is, or the
Yes.
particulars of claim,
Yes.
as may have been amended. So
Yes.
the settlements were close to what was claimed. I can
Yes.
safely say so.
Yes. In your experience, is that quite normal when you talk about a settlement? In your experience, how many years had you been in practice by then?
I was admitted in May of 2000, so it's 20 years now.
Yeah. So you had about 17 years at the time of the settlement, more or less.
Correct.
Yes. In your experience, was it quite usual, has it been usual in your experience to settle or to have matters settled on a basis in terms of which the defendant
It's being sued.
pays or tenders to pay either the exact amount claimed or very close to it? Is that something that you have found quite common in your experience over the years?
Settlements would, in my view, be a product of negotiations between the parties. If I were to speak about the extent of our firm's involvement, that did not happen. I was not asked, or let me put it differently, I was not involved in the computation
Yeah.
of the final figures, and therefore it will be difficult to say, no, this amount should not have been tendered, but that should have.
Yeah.
I did not do the exercise
Yes.
after I was given such instructions, because I
Yes.
accepted that PRASA was satisfied, or where the instructions came from, the relevant officials were satisfied that what they wanted me to tender is what they thought PRASA was liable for.
Yes. No, that's fine. I was asking a different question, and that's where I want you to assist me.
Yes.
I haven't been in practice. I left practice about 23 years ago. So, and when it comes to settlements, as you know, judges normally don't get told what the settlement was. So, but my reaction when I noticed that the amounts you were instructed to tender seemed to be exactly the same amounts claimed in the summons. At least that was my impression. That didn't strike me as a settlement as one would normally expect. But maybe it's because I've not been in practice for over the past 23 years. Maybe things have changed. Are you able to assist me to say, well, things have changed, you don't know what is happening out there now, this is normal? My experience was that there would be a kind of, if you're talking of a settlement, you'd be looking at about a very different amount from the amount claimed.
We generally say that a good settlement is a settlement out of which none of the parties are happy, which means your plaintiff does not get quite what they may have been looking for, or your defendant doesn't pay, they find themselves paying more than what they may have bargained for. So yes, Chair, you would find that we don't ordinarily normally pay what is claimed for in the particulars of claim.
Okay.
Just
Well,
one,
Mr. Soni might have better experience because he's still in practice, so.
yes, I can say that law hasn't changed since you.
Yeah.
There's just one other clause that I'd like us to look at, Ms. Mogashoa. It's at page 22 under C.
Or maybe you might or might not be able to comment on this, Mr. Mogashoa. I'm sorry, Mr. Soni.
Yes,
I
Chair.
think Mr. Dingiswayo, if I'm not mistaken, said in his affidavit or maybe also in his evidence that this was not a settlement, it was capitulation. Do you
I
want to
remember
comment
seeing-
on that? Eh?
I remember seeing that. Well, if you compare the figures of the tender to the figures as they may appear in the particulars of claim, one would look at it that way, that it's a capitulation. And I think it's even more confusing when such matters have had some life of being defended. And then after 2 or 3 years, then it's a settlement, and it's a settlement of the full amount. It can create some uncertainties.
Of course, what one can't deny is that if indeed PRASA had no defense to the claims, it may well have been a reasonable thing to pay at that time and save all the legal costs that would come with the arbitration. Isn't it?
I
That is,
agree.
if PRASA had no defense.
I agree
Yeah,
fully with
yeah.
that. If we couldn't
Yes.
find anything wrong with the
Yes.
invoicing or the figures,
Yes.
I accept that
Yeah.
yes, one would have
Yeah.
had to
Yeah,
make
okay.
that kind of a settlement.
Okay. I'm sorry, I interrupted you, Mr. Soni. You had a question.
I've got my point again, Chairperson. If you look at paragraph C, you might remember the Chairperson asked you, was there anything unusual? And you've debated that issue with the Chairperson. But have a look at paragraph 2.C regarding the interest that was to be payable. .7 on page 22.
Correct, I see that.
What does it say?
Well, it simply says that interest must be calculated from the date of issuing the summons instead of being calculated from the date of the issuance of the invoice itself,
Okay.
or invoices.
Now, based on this instruction, what did you do? This written instruction?
What would I do?
No, what did you do?
Oh, yes. Okay.
So maybe before that, so to sum up, your instructions are tender, it's either the amounts claimed in the summons or something more or less the same, and tender interest from the date of summons, for the date of, from the date of summons, that's what it says. So far, it looks like the only thing that is not mentioned on your instructions is costs. Is that right?
That is correct.
Yes. It looks like the instruction letter said nothing about costs.
The instruction letter indeed did not say anything about costs.
Yes. Okay. Mr. Soni asked you a question about the interest. You might wish to repeat that question about interest, yeah.
Sorry, I was asking about what happened next year.
Or what happened
Oh,
next,
yes.
yeah.
Oh, yes, Chair, what then happened is I then formulated the tenders in line with this letter of instruction, and I may have sent out the tenders on the same day or the day thereafter. I remember we produced two documents, one in respect of the CIR rail solutions matter, the 19 million rand tender, and separately from that, and in respect of the three claims under the CIRDB consulting engineers, we issued another tender. So it was two tenders, one with details of the three claims and the other one with the details of just this one claim under case number 47597 of 16. I don't know whether I dispatched with the tenders the same day on the 15th or the next day on the 16th, but I remember we then managed to structure the tenders in line with the instructions and transmitted them electronically to our opponents.
Yes. And how did they respond to the tenders you have made?
We don't have your letter in which you made the tender, eh? I don't see it here. We don't
It's
have.
not.
Okay, all right. But you made a tender in accordance with your understanding of your instructions.
Correct, that is exactly what happened.
Yes.
And I think I do say in my affidavit that a day or two thereafter, I received a letter which I probably refer to in my affidavit.
It's at paragraph 34, MM2.
Yes, in which my opponent acknowledges receipt of the tenders made, but then they went on to raise an issue to do with interest because I had not included interest in the amounts that were part of the first tenders issued out.
Okay. So that they address in paragraph 3 of their letter, which is at page 25 of the annexes to your documents.
Correct, that's what the letter
So
reads.
just read that paragraph out.
I'm
Oh,
sorry. Are you at 25?
At 25, Chairperson. This is
Okay.
the opponent's response to Mr. Mogashoa's tender.
Okay, we are now dealing with Annexure MM2, which appears at page 24, and it is a letter from Matopo attorneys dated 18 December 2017. Yes. Before you read what Mr. Soni says you should read, I see in paragraph 1.1 of that letter that Matopo attorneys say we represent CIRDB Consulting Engineers Pty Limited in liquidation and CIR Rail Solution Pty Limited hereinafter collectively as our client. I thought that there were different attorneys for the liquidators and different attorneys for CIR Rail Solution. Was that not the position?
No, that was not the position, Chair. You would recall
That was or that was not?
it was not the position.
Okay.
You would recall that earlier on, I did mention that soon after gaining information that the CIRDB was
Under liquidation.
under liquidation, we then asked for the requisite mandate and authority from Mr. Matopo in order that we get satisfied that he continues to act for CIRDB even when it is under liquidation, and we were provided with such mandates.
Around about when would that have been? You were now talking about 17 December 2017.
it may have been around May or June of 2017,
or much earlier?
much earlier, soon after we became aware of the liquidation process against, or in respect of CIRDB in April, around middle of
Yes.
April. I think we do say that on the 17th of April or so.
Yeah, but I thought Mr. Portes, when he gave evidence here, and I thought I read in the papers that at the time that he was talking to the PRASA chairperson, at the time Mr. Portes was talking to the PRASA chairperson, and there was communication about settlements, which I think would have been around November, December. Around that time, I thought Mr. Portes said there was a Mr. Krause or somebody who I thought represented the liquidators. And the impression I had was that Krause attorneys represented the liquidators and Matopo represented another entity. That's why I'm picking this up and I'm surprised by it.
Yes, we soon after gaining knowledge of the fact that the DB or CIRDB aspect of the CIR group of companies had been placed under liquidation, we naturally approached Mr. Matopo and inquired from him if he continued to act on their behalf, given that they may now be under a different
Under someone else's control.
legal personality, under someone else's control and so forth. And I think after a while, he came back to us. I just don't have the documents in front of me, but I remember very well, because we were not going to move on litigating with him in circumstances where our client was not satisfied that he continues to enjoy the mandate of the CIRDB consultancy, which was under liquidation at the time.
So is the position that earlier on, Matopo attorneys represented all the CIR companies that were involved in these claims initially?
That has always been the case, correct?
And then you say at a certain stage, April 2017, you became aware that CIRDB Consulting Engineers was under liquidation and you sought proof of authority and that was supplied in due course.
It was made available.
Yes.
Correct, Chair.
Now, does that mean there are no other attorneys that, as far as you know ever represented one of the CIR or one of the CIR companies in regard to these claims while you were involved for PRASA?
Around the time subpoenas were issued by the Liquidation Commission or Insolvency Commission, as we may want
The
to call it,
inquiry here.
there was a law firm that had issued those letters on behalf of the liquidators. But our office continued to communicate with Mr. Matopo's office on the basis that his firm still represented the company in liquidation and the CIR, the CIR Rail Solutions Company.
And Mr.
But it-
Portes had been briefed by Matopo attorneys.
That was my impression.
Yeah, okay.
But if you look at communication around the time the offers were accepted, Mr. Duotes seems to now make a distinction between the company in liquidation and CIR Rail Solutions, and I suppose he went on to provide us with two different accounting details or bank account details into which PRASA would have had to pay the amounts. And this was simply because he says that the other company
Was not
had
under
to be
liquidation.
paid through a different trust account than Matopos, as may have been the case in the CIR Rail Solutions case.
Well,
Chairperson, you've picked up something very important, and I must apologize for not picking it up. But if we look at page 27, you will see that this letter from Mr. Matapo says that the amounts must be paid into Mr. Krause's trust account. At the bottom of page 27, Chairperson.
Yes.
Both the amounts must be paid into Mr. Krause's trust account.
Or both amounts, actually?
Yes.
That's very strange.
It is. And I'm sorry I didn't pick it up,
Yes.
Chairperson.
Can you see that, Mr. Mogashoa?
I can see that, yes. It says in both instances, the account of Kraus trust account. It may be different account numbers, though, I don't know. But yes, I see paragraph 9, 9.1 and 9.2.
Would you know whether Kraus Incorporated were attorneys or was it a firm of liquidators or what? Would you know that or not?
I'm not sure about
Yes,
that.
you never dealt with them directly.
I had not dealt with them until the time
Yeah,
that we attended the commissions inquiries hearings in August.
yeah, it's a little strange.
It is.
Yeah, normally attorneys would let payment be made into their trust account to pass the matter to the client. Or otherwise, I guess it would go to the client, but Kraus is not the client.
Yes.
But a distinction is made, because if you look at paragraph 9.1, Chair, it says CIDP in liquidation. So it is not clear, I suppose, to all of us. While paragraph 9.2.
You see, paragraph 9.1 relates to a company that was in liquidation. Paragraph 9.2 relates to a company that was not in liquidation, but payments to both companies was to be made to the same entity, entity's trust account, Kraus Incorporated.
Yes. I see.
It's strange that in relation to the litigation, Matopo attorneys acts for both, and yet when it comes to payment has to, in regard to both, must go to somebody else that at least we seem to know nothing about. At least you knew nothing about Kraus Incorporated.
I take the point.
Yeah, yeah.
So I should look a little more carefully at the papers for next time.
Yes,
Because I know there is a letter that Judge Makubela referred to from Kraus attorneys, saying that she had received a letter from them.
Yes.
I just can't
Yeah, it
put
might
my
need to
finger
be
on
checked.
where
Yeah.
exactly it is.
Yeah, yeah. Yes.
I just want to go to paragraph 3 now, Ms. Mogashoa, at page 25. Because this is what Mr. Matapo writes to you. Could you read that into the record?
He says on paragraph 3 of his letter,
Yes.
your client, PRASA, did not instruct you to submit an offer or tender to our clients in respect of the capital amounts only. Your client's specific and express instruction to you was to submit an offer or tender to our clients which provides for payment of interest, a temporem RAI at the rate of 9% per annum, calculated from the date or dates upon which the respective summonses were served on your clients.
What was your reaction upon receiving that letter? You'd been instructed to issue a tender, which you did. And now you are told, but the tender is not in terms of your instructions. Well, what was your reaction to that?
I think naturally my first
You
reaction was,
deal with it in paragraph 34
yes,
of your affidavit,
and that is on page,
at page 14. So just after MM2, which is in bold, do you see it?
Yes. Paragraph 34.
I'm sorry, you are speaking away from the mic.
Oh, yes.
Start afresh and so that what you say will be recorded.
Okay, Chair. Must I continue now?
Yes, but start your response afresh because I don't think it was captured. Whatever you said, I don't think was captured earlier.
Okay. Paragraph 34 of my affidavit. I think on the paragraph, I'm simply summarizing what I'm saying was a bit of a challenge for me in that I had made a tender, and when my opponent writes back to counter-propose, so to speak, reference is made to the fact that my tender is not in line with the instructions I had expressly received from my client. But I think I made the point as well that I said to my opponents that I would, in any event, irrespective, just go back to my client and confirm their instructions in as far as the issue of interest is concerned.
Yes, but I'm raising a slightly different point.
Yes.
How would they know what your client had instructed you to do? I mean, we know now that they did know. Did you ever find out?
I was equally taken aback by that. You may see that at the end of paragraph, I'm not sure if I took that issue up with them.
I don't think you did, certainly not in your affidavit.
I don't think I did in writing, or maybe it's correspondence I did not want to at the time deal with. But yes, I found it a bit troublesome that my client's instructions were not only known to me, but from the reading of the letter of Mr. Matopo, they as well had been placed in possession of the same letter that was addressed to me.
So can I give you some background to that? When Mr. Bothus gave evidence, he said that this letter had been WhatsApped to him. He received this letter by WhatsApp from the chairperson of the board. That was his evidence.
Oh, okay. All right. I did not get to see any of the submissions he made.
No, I understand.
It explains how the letter got to them.
All right. Now, having received that letter, the MM2 from Mr. Matopo, what did you do?
I then immediately approached Mr. Zide, client, and I indicated to them, and I may, if you allow me to get to MM3.
Yes.
Because I may have said to client that it's concerning
That's at page 29. MM3 is at page 29. And your email is the second email on that page.
But I think the attachment does not quite deal with the concern I had.
Yes.
I may have simply forwarded the letter to client, and client then gave me instructions to investigate how to incorporate the interest that is referred to in their initial letter of instructions.
Okay. And did you do that?
Yes, we went on to instruct our accountants to give us a table of such figures as it was required that they include interest. They made such figures available to us, and I forwarded the figures to Mr. Zide with recommendations that I had satisfied myself with the Interest Incorporated, and his instructions were that I then should proceed to revise the offers to include the interest that then was calculated on the basis of the capital amounts.
Now, that offer then was sent to Matapo attorneys.
We then sent the offers to our opponents.
What was the response to the offer? Well, firstly, from whom did you get a response to that offer?
I may have received a response from Mr. Brotas.
If you look at MM4 on page 30, this is the top, the top half of MM4, page 30.
Yes, I see that.
Now, that's an email from Mr. Botus dated when
Dated the 21st of December.
and to whom is it addressed?
It is addressed to Tapa Matopo, but we are carbon copied.
Well, just read the names of all the people who are carbon copied.
Okay, people who are carbon copied are Tapa Matopo, Navega Zimbabwe, Madimpe Mogashoa, TAN Makubele.
And who is that?
This would be the chairperson.
Yes. And you'll see there's also Mr. Krause.
Mr. Krause is CC'd there as well, yes. And Hannes from Tswane Trust.
Now, in essence, what does Mr. Botus say in regard to, well, it's a strange thing. The email is from Mr. Botus, but if you look at the bottom, who signs it?
Yes, I see it says Matopo Tennis.
Yes. Now, what is the essence of that email?
I see that it refers to the offers we made. The first point they make, the email makes, is that PRASA's settlement offers are accepted. The email further makes reference to the issue of interest. And I think it repeats the same debate I had with Mr. Matopo around interest and the inclusion of interest in the figures. Mr. Botus goes on to suggest that payments be made into Kraus Inc.'s trust account, and that he hopes that our client will expedite the payment issue.
Yes. Now, what was the next thing that happened in regard to those communications? And you'll actually find that in MM5 at page 31.
All right, what I see on page 81, if I may proceed.
Yes.
What I see on page 31, annexure MM5, is that on the same day I received an email from the chairperson in which she says that, "Dear Madimpe, thank you for the update. Mr. Zide, please attend to finalize the matter with regards to payment." And this may have been because her email was in response to mine that I had sent earlier.
Is that the email just under that?
Yes, in which I say, but this is an email addressed to Mr. Botus.
Yes, sorry.
And everyone else. But if I send this in reply to Mr. Botus, then the chairperson would have received it.
Yes.
Because she was carbon copied.
I should have referred you to go back to page 30, and in the bottom half you'll find an email from yourself.
Oh yes, that's MM4.
Yes. And what does that say? Well, it doesn't say to whom it's addressed. It seems it was sent from your iPhone.
It could be, it says, good morning, says, that's the 1023 email.
Yes.
It says, good morning, says, attached are revised offers in respect of matters with case numbers. And it's the 4 case numbers in respect of which the offers were made. Kindly obtain instructions from your clients and revert.
And it's in response to that offer that Mr. Bouters says we accept the offer.
So then I think then Mr. Botha's email of 1121 is in response to mine at 1023.
Yes.
Then I then see that what happened here? I'm looking at the last email on page 30. 1125.
Yeah, that email is incomplete. It's not.
Yes.
Anyway, let's not get bogged down. What we do know is that the offers were accepted and the chairperson told Mr. Zide to deal with the question of payment.
Correct.
Matopo attorneys raised the issue of interest in response to your first offer or tender. But I thought that the instructions you had received did include that you must tender payment of interest from the date of summons. Is the position that your first tender did not deal at all with interest, or is it that you said interest would be calculated from a date other than the one that Matopo attorneys understood you to have been instructed to work on?
It did not, the offers did not at all deal with interest. And I think it was just inadvertent on my part.
Yes, because...
Not to include interest. I may have missed that part when I formulated the offers at that time.
Yes, but subsequently you saw that it was there.
I saw that it was there, but you would see that I contacted clients to say, look, this is what my opponents are saying. I'll just rework to include interest. Yes.
Okay.
All right. Then you say that at paragraph 36, on the 8th of January, you received a letter from Mr. Matapo, indicating that they have a proposal in respect of the matter that was not included in the settlement. Remember, there were 5 matters, 4 were settled. What did you do with that offer?
You mean the letter?
I mean that letter.
I sent it to client.
And what was the response from client?
Let me see what my affidavit says about that. And I believe that the offer made proposals on how we could deal with that particular case. It's case number 74281 of 2015. I say that despite that this letter was forwarded to PRASA for their consideration and instructions, no communication has since come forth from client.
Okay. Now, the rest of paragraphs 37, 38, and 39, 38 and 39, deal with the fact that certain communications were made to the arbitrator relating to these offers.
Yes, that is it.
And then in paragraph 39, you deal with a message you received from Mr. Zide. What was that in connection with, at paragraph 39?
Okay, Chair. The point you make earlier about the fact that the rest of the paragraphs, 37 and 38, dealt mainly with the communication between my office and that of Mr. Matopo, and further with communication between Mr. Matopo's office and that of retired Judge Brand. Then come into flow with what I say in paragraph 39. In essence, Mr. Matopo was getting frustrated with the fact that PRASA was not making the payments following the acceptance of the offers, and he then started engaging with the judge in order that we make, and in anticipation, of course, further of the arbitration dates that we're approaching in March. He suggested that the parties approach Judge Brand and present to him that the parties have arrived at settlements in respect of some or most of the matters, and that they wished that such settlements be made arbitrators' awards. I imagine at the time the thinking was that they then go on to make them orders of court if the issue of non-payment continued.
Right.
So
that communication is sent to you, they want to make it, and they want to make the settlement into arbitration awards.
correct. So it will be communication with Judge Brand, but I'm CC'd and copied.
Yes. What did you do when you were copied?
So every time I would receive such communication, I would forward all of the communication to Mr. Zide.
And
So
in regard to that communication, what was the communication from him to you?
in paragraph 39, I then deal with, I had been, Judge Brand was in Gauteng at some point, and I think he had other matters he was running with. Mr. Bottas, or Advocate Bottas, managed to arrange that the parties see him on one particular day. Now, it has always been my position that I wasn't going to act or do anything unless I'm instructed. So I think it's a text message that I'm referring to in my paragraph 39 that I received from Mr. Zide, confirming that that day I was then instructed to proceed and participate in submissions to Judge Brand and make the settlements arbitrators awards as consented to by both parties.
Okay, have a look at page 41. That's the message you referred to at paragraph 39. Page 41.
Correct, the first message.
Yes. And what does that message say?
The message was from Mr. Zide, and it was addressed to me, and it says that, yes, Mogashoa should confirm that the settlement be made in order and proceed with arbitration on the one that had outstanding issues. And
then
Mr. Zide goes on to say that that's from the chairperson.
So what did you understand from that?
I understood that my instructions were that I proceed to see Judge Brand with Mr. Bottas and make the settlements the arbitrator's award or consent thereto, and further that I present to the retired judge that the only outstanding matter that the parties had to deal with, perhaps at the scheduled arbitration, was that the parties could not settle.
And from whom was that instruction that it be made an an arbitration award?
From Mr. Zide's email, the text that I'm looking at here, Annexure MM9, the message by him to me may have been from the chairperson. It is from the chairperson because he says that it's a message from the chairperson,
Yes.
from his second text to me.
So, in a direct answer to my question, from whom was the instruction that it be made an arbitration award?
From the chairperson.
Then you say that there were further instructions given to you, and these were at paragraph, at page 42, MM10. Oh, sorry, not instructions, but you then received applications to make the arbitration awards, orders of court.
Yes, I think the
That you
issue
deal
of,
with at paragraph 40.
yes, the issue of non-payment continued, and then we were served with on behalf of PRASA, we were served with the applications to make.
I'm sure, Mr. Son, you can go to that strange fish about that, because none of that is disputed.
Okay.
What happened, yeah.
Yes.
There was just this strange fish about the authority. I think that's the
Yes.
only thing, as far as I can think of,
No,
that's of
no.
importance, yeah.
I'll just do one small thing and then I'll explain
Yeah.
why I'm going there.
No, that's
And
fine.
at paragraph 41, you say you received a call from Mr. Ndingizwayo.
Yes, on the 5th of March.
And what was that call about?
He said to me that he had received, I think he was talking to a colleague, not at PRASA though, on issues unrelated, and the colleague made him aware that Siyaya had enrolled 4 matters. for
Well, those are
hearing.
the matters that you had sent in to PRASA that we had just talked about.
I had sent the 4 applications
Yes.
to PRASA already, to Mr. Zida's office to say, here are the applications, what do you want?
After your conversation with Mr. Ndingizwayo, did you and he hold a meeting?
Yes, Mr. Ndingizwayo then asked for copies of the applications, which I forwarded to him accordingly, and then I was invited to a meeting at which I think Mr. Malepo, who was the acting CEO at the time, was present, and Ms. Ngoye was present, and Mr. Ndingizwayo was also present there. I went to the
You
meeting
say
with
in paragraph 42, Mr. Zide was also present.
Mr. Zida was part of the meeting, yes.
Yes. And what happened at that meeting?
At the meeting, legal presented to Mr. Mlepo that the settlements, as may have been referred to in the applications themselves, had been entered into without legal's involvement, 1, and 2, that the chairperson did not have the authority to get PRASA into such settlements as may have been alluded to in the applications themselves.
And
Was
what,
this on the 8th of March, 2018? In terms of time frame, I see you seem to say so around that time.
Yes, I think the date of the meeting is 8 March 2018,
Okay.
according to my affidavit.
and all of this happened on the 8th of March that you're talking about now.
I may have received Ndingizwayo's call earlier, but the meeting took place on the
On
8th
the
of
8th,
March.
yes, you say you met him you got a call from him on the 5th.
Oh, yes.
So this is the 8th. Now, in light of the fact that you had been part of the settlement on the basis of instructions received from the chairperson, what was your further involvement in this matter?
Ms. Ngoye made a valid point at the meeting that another law firm be instructed to carry on with the instructions, more so because there was a need for them, an identified need at the time for them to oppose the applications which the applicant had enrolled in respect of the 4 matters. I can't remember what the date was.
It was the 9th.
That the applications stood to be had. Because obviously I'm the one who had been instructed in all of the processes that led to that settlement at the time.
And what was
Which-
the
which-
conclusion at the end regarding your
Then
further involvement?
the conclusion was that another law firm would be briefed and that I should assist with handing over my own set of papers to this law firm. I think it was Bowman's.
Yes.
And that is exactly what our firm did. We filed the relevant notices of withdrawal.
Withdraw.
Settings.
And you withdrew formally.
We withdrew formally. correct.
You have no further knowledge of what happened. I mean, no personal knowledge of what happened in this matter in court.
Well, if my recollection serves me well, they may have been denied I think they opposed the applications, but orders were granted, I believe, but they rescinded such order or orders subsequently. And I'm not sure where the matters are now as we speak.
We'll get to that in a moment. But when the application to make the arbitration awards orders of court was made, you were not representing PRASA.
I stopped representing PRASA on the 8th. The applications,
On the day before.
The applications were in our possession already.
Yes.
And then PRASA opted to instruct another law firm
No,
to proceed with
no,
the
I understand. We've been through that. I'm just asking, in the court process itself on the 9th, you had no role in that.
We were not involved.
And that's all, that's the extent to which your personal knowledge relating to the CIA matters extends.
That is correct.
Now, you make the point right finally that all of this is based, what's contained in your affidavit is based on the documents that were in your possession at the time you made this affidavit.
Correct. I had to pull out certain portions of the files from archives in order to prepare this affidavit.
Chairperson, those are the questions I have for Mr. Mogashoa, having regard to the fact that effectively from the 8th, he played no further role in this matter.
No, that's fine. I think it didn't occur to me that at the time of the application before
Acting judge.
I think an acting judge,
Yes.
that he was no longer involved.
Yes.
So when I referred to that
And-
special fish, I was talking about something that happened in
Yes.
court, thinking he would have still been part of it.
Yes.
No, so he wasn't. Now, you withdrew either on the 8th of March as the attorney of record for PRASA in regard to the CCA, in regard to the CIA matters, or soon after the 8th of March.
It may very well be that we filed our withdrawals on the same
On the same day.
If Mr. Soni is right in suggesting that the applications were to be held on the 9th.
Yeah, I think that's what we have been told. Now, when had you last interacted with the PRASA chairperson by then? Did you interact with her after the meeting of the 15th of December, between that date and the 8th of March?
The only interaction with her would be this email that she wrote to me,
Correspondence, yeah.
the correspondence.
But there was no meeting
No, we
and
did not hold
no
any.
speaking on the phone with her?
We did not speak on the phone
You
either.
did not speak on the phone.
No.
What made you accept discussing the CIA matters with the legal department on the 8th, despite the fact that you had been instructed by the PRASA chairperson previously not to discuss those matters with the legal department?
I think part of it would be, or would have been, the frustrations I was experiencing in getting to know from PRASA what the firm was to do with the 4 applications, because up until that point, I had not received any indication of any kind whatsoever what PRASA intended to do with the applications. And I had no reason not to want to cooperate with Mr. Tingizwayo when he called and asked about the applications, because we had the applications in our possession.
But what I'm talking about is, I would have expected that given the instruction that you told me about, which you said came from the PRASA chairperson to you, not to discuss the CIA claims with PRASA's legal department people, I would have expected that when Mr. Dingiswaya approached you and sought to make an arrangement, you would have gone back to the PRASA chairperson to say, you said I mustn't talk to the legal department. They have phoned me, they want a meeting. Do I stick to that instruction, or has something changed?
At the time...
And Mr. Dingiswayo knew that as well, because you told him.
Yes, at the time, Chair, and I think it must be taken into account that I was not talking to the chairperson directly, whether in writing, through email correspondence or otherwise. I had been communicating with or through the office of the group company secretary, Mr. Zide. It would have been irresponsible of me when, at the time I received a call from Mr. Tingizwayo, it would have been irresponsible of me to completely ignore what he had called me about, given the fact that I wasn't receiving any instructions. I was actually relieved that someone from PRASA called me about the matters. I obviously may have asked him what was going on, because I wasn't receiving any feedback or instructions from the channel or channels that I had gotten used to between December and March, when I started talking to him again. And as I say, I then decided to forward the applications to him without asking any further questions, because I expected him, as someone I knew was still at PRASA, to take responsible decisions around the applications. I had not been briefed on any aspect to do with the applications. I was worried that then PRASA was going to be unrepresented, because I was not going to go to court the next day without specific instructions on what my firm needed to do.
We know that the acceptance of the settlement agreement, of the settlement offer, was made around 17, 18, 20, 21 December, is that right?
Correct.
Now, after the offer had been accepted, there was that communication about payment. Matropo said, please attend to payment urgently. And I think you would have sought instructions from the company secretary, is that right?
Correct.
Or maybe let me clarify that. Initially, you were meant to communicate with the board through the office of the CEO, when Mr. Zide was the acting CEO. Is that right?
At the meeting of the 15th of December, I was not aware that Mr. Zide had stopped acting as the, Chair, as the group CEO of PRASA. But the instruction to me by the chairperson was that any communication must be through Mr. Zide's office.
Yes, my understanding is that when that instruction, or let me put it this way, was when that instruction was made, was Mr. Zide not acting CEO anymore?
I was under the impression that he was, but I think Mr. Soni,
Was it not on the, was it not at the meeting of the 4th of December?
at the meeting of the 4th of December, he was still the acting CEO.
Yes, but when you were given this instruction, was it not at that meeting? Or was it at the meeting of the 15th?
It was.
No, it was at the meeting of the 15th, I think, because you then phoned Mr. Dingiswayo on the 15th, I think. I think you said that that instruction was given to you at the meeting of the 15th.
It was given to me at the meeting of the 15th, not the 4th.
Yes, but you are saying that at that time, you were under the impression that Mr. Zidi was still acting CEO.
I was under the impression that Mr. Zidi was the acting
Was still
CEO.
acting CEO.
Yes,
CEO.
but- Yeah, but I know him to be the group,
Company
or to
secretary.
have been the company secretary.
Yes,
So when the chairperson was giving instructions on how communication will be dealt with, I think to me it was more Mr. Zide
The person.
as the person who works with the board, more than it was important for me to make that distinction whether he was still acting as the
yeah,
group CEO or he had
Yeah.
reverted back to his original position.
yes. But from January, had you asked for any instructions from PRASA and you didn't get a response?
I think Mr.
During
Soni took
January,
me through
February.
one attachment which I received by text. That's the meeting between, the meeting that the parties had decided to hold with Mr. Brand to confirm some of the settlements. But otherwise, so that's those are the instructions I received, because I had to take instructions on what PRASA wanted me to do, with the fact that the plaintiff wanted to make those settlements arbitrators awards. The other normal communication would have had to be about payments that the CIA group was complaining were not forthcoming. And then the next big thing then was the applications themselves, which I forwarded to PRASA through the office of Mr. Zide, and what then transpired was Mr. Dingiswayo's call. And then the handing over of such applications to him.
The meeting of the 8th of March, you say it included Mr. Zide?
Mr. Zide was present. at the
Yes,
meeting.
yes. So, you see, I was just concerned that you didn't go back to the chairperson when now it seemed that you were going to meet to discuss CIA matters with people that he said you mustn't discuss them with. But there was Mr. Zide who was there.
Mr.
And
Zide
maybe
was
that is
present.
what that made a difference to you.
Mr. Zide was present, and yes, it
Yeah.
made a difference to me.
Yeah. Okay, no, that's fine.
And possibly I'm probably correct in making this suggestion. When Mr. Dingiswayo asked that I forward the applications, we in all probabilities CC'd Mr. Zide. Because I had no reason to want to not have him know
Yeah,
that legal had asked for those applications from me.
yeah. Did you ever deal with Mr. Mulepo? I think he was the acting CEO after Mr. Zide ceased to be acting CEO.
No.
You never dealt with him? Yes.
The first encounter, Chair, was that meeting and nothing ever since.
Or was he present at the meeting of the 8th?
He was. I think the meeting was called
Oh.
by his office.
Or Mr. Mulepo?
Yeah, well, seemingly at the insistence of legal,
Oh,
which had become aware about the
yes,
applications.
yes. Are you able to tell what his attitude was to these settlements that had happened? Or are you not able to tell from the discussions at the meeting of the 8th? Or the whole topic was different by that time?
I think he was concerned because he did not have any trouble
With the
having
proposal.
legal proceed with the
Yes,
opposition that they had intended
yes,
mounting against the application. So
yeah,
in as far, well, to that extent, one thinks that he agreed,
yeah,
or he was in agreement with
with that
legal
approach.
that a different approach should be
Yeah.
taken.
Yeah. The idea that the settlement agreements should be made arbitration awards, was that part of the settlement agreement? Was there a clause in the settlement agreement that said that? Just seems strange to me that unless it's included in a settlement agreement, it seems strange that I'm going to agree that I'm going to pay you and we sign. And then I also agree that let's make this an order of court. But if at the time we made the settlement agreement, that was part of the settlement agreement, that may be different. Because otherwise, if it's not part of the settlement agreement, if I've agreed that I'm going to pay you, then I pay you within the time that I've agreed to pay you. And of course, if I fail to pay you, you might have cause to want to make the settlement agreement an arbitration award or order of court. But normally you'd wait until you see whether I've complied. I just find it strange that PRASA, you were instructed to agree to having the settlement agreements made orders or arbitration awards.
I think if you look at the timelines, Chair, if we accept that the settlements were agreed to around the 21st of December,
December, yeah.
this is now beginning of February that
Yes,
Mr. Matopo is beginning to complain. And,
that the period of payment had expired.
well, reasonable period
Yeah.
had expired, although
Was
I
there not a
doubt-
specific period mentioned, like 30 days?
I doubt that the tenders had stipulated any period.
Yeah, or.
I think, because otherwise we will be making a lot of reference to the period
Yes, yeah.
referred to in the tenders. So
Yeah.
they probably thought that whatever number of days that may have lapsed since they accepted the offer
Yeah,
were enough to have them start complaining about the fact that they're not getting paid.
okay, no, that's fine. Anything arising?
Nothing else.
Nothing. Thank you very much, Mr. Mogashoa, for having come to assist the commission. We appreciate that you may have been like us. You thought this might have taken 2 hours. It ended up taking the whole day, but we appreciate that you came and you have given your evidence. Thank you very much.
Thank you, Chair, and I'm glad that I could be of some assistance.
Yes, you are excused.
Thank you very much.
We are going to adjourn for the day, and tomorrow the sitting will start at 10, at 10 o'clock. We adjourn.